Welcome, everyone. This is hearing day 15 for the Inquiry and Advisory Committee hearing for Kentbruck Green Power Hub project, the Environment Effects Statement hearing. This hearing is being audio recorded and the recordings will be available on the Engage Victoria website. My name is Lisa Kendall and I am the chair of the Inquiry and Advisory Committee appointed to consider this matter. I'm joined today in the hearing room by Member Michael Kirsch on my right, Member Lachlan Wilkinson on my left, and Member Ken Joyner is joining us online. And I'm just going to pause for a moment and confirm that Member Joyner is with us. And it's just not coming up on my screen at the moment with his camera on. So I might just ask the PPB team to just check that his tech is working okay. But in the meantime, I'll move on with some of the preliminary matters we need to discuss this morning. So hearing day 14 was a reserve day and wasn't needed. So today we're working to timetable version 7. We'll be hearing submissions from the Department of Energy, Environment and Climate Action and Parks Victoria, represented by Mr. Tobin, who's with us today. We did receive written submissions yesterday from DECA and Parks Victoria. Thank you. So documents 393 and 394. Mr. Tobin, I just see in the reissued timetable that we've got DECA submissions split across the morning and the afternoon with a small amount allocated to DECA in the afternoon. No problem, thank you. I'm just wanting to confirm if you think DECA submissions will be completed in the morning session, and if so, we might push on until that's done rather than coming back for, I think it would look like 15 minutes with sitting on the other side of lunch. So I just wanted to check if that sounded logical to you.
Good morning, Member Kendall. I can confirm my expectation is that DECA's submission will be completed before lunch, and I had contemplated that if there was more than a few minutes, we might move to Parks Victoria's submission, but I'm in your hands if the timetable reads as the timetable reads and you'd rather wait.
No, I'm happy for us to just continue if that's where we're at in the hearing. I thought I'd table now that mention that if you've got 15 minutes to go and it's 1 o'clock, let me know. I'm very happy to continue rather than split those submissions. Thank you. But if you're running ahead and Parks Victoria submissions can commence earlier, that's perfectly fine. Thank you. For tomorrow's timetable, we've had a couple of changes. Parties may have seen this in the table documents, so we'll no longer be hearing verbal submissions from Jimmy Onus or Doug Munro. So the timetable will be amended accordingly. So we'll be only sitting for part of the morning tomorrow. I will just mention for the information of parties that for Thursday we have scheduled to hear submissions from Save Our Surroundings Riverina and hearing evidence from Ivan Kennedy, Grant Piper and Aidan Morrison. Ms. LeBlack has advised she won't be attending the hearing and will be relying on her written submission, but the evidence of the 3 experts will at this stage, we understand they're still attending the hearing and will be presenting their evidence, and I note that they did circulate written statements as agreed by the IAC. So at this stage, we anticipate that the IAC will introduce the experts and invite them to present their evidence, and then we'll invite parties to ask questions of cross-examination. So I don't know if parties who are with us are in a position to advise the proponent and other parties if you're intending to ask questions of those experts, just to give us an idea of the timetable planning for Thursday.
Yes, so if I understand correctly, what you're contemplating is that the experts or the witnesses perhaps would attend and would present their evidence, notwithstanding they wouldn't be called by a particular party.
That's right.
And be made available for cross-examination?
That's right.
Okay. In that case, yes, we intend to ask questions of each of the witnesses.
Thank you.
Are they going to be do we anticipate them being in person or?
We're waiting to hear that, Mr. Chessel. So if we do know, I'll give you an idea of what we've been advised.
Okay.
Yeah.
But yes, no, we do intend to ask questions.
Okay, thank you. Do you have any idea at this stage of the extent of question?
Look, we've only had preliminary discussions about that, but we're mindful of the time that's been allocated to that submitter in total. And so we'll look to conclude our questions efficiently, but I can't yet tell you exactly how long we're anticipating for each witness, but it's not going to be hours. It will be far shorter periods of time we're anticipating than that.
Thank you. Obviously, our directions were for parties to advise by lunchtime tomorrow of their intention to ask questions, but I just thought it was worth noting that change in terms of the submitter representation. Do you have anything, Mr. Tobin?
Neither DECA nor Parks will be asking questions. We anticipate that after today, our involvement in the hearing will be observational for the balance of the hearing up until the time that's tentatively allocated for a reply submission should anything arise from those observations, and then the proponents closing. I should say, in case you're worried, except for our filing on or before the 9th of July, the incorporated document and the EMF.
Thank you. Thank you. So we have received a number of documents. I won't go through them in any detail, but just to note, we've received correspondence from the proponent with an updated request for information response table. Thank you. It's document 399. And we have also received the Day 2A version of the Environment Management Framework, which I think is document 400. I didn't double check that. DECA's submission, as I've mentioned, and the Parks Victoria submissions, and further documents relating to the Parks Victoria submissions that I'm sure you'll talk us through, Mr. Tobin. So no further preliminary matters from the IAC. So I'll ask the proponent if there's anything else we need to cover this morning.
Very briefly, you've identified the two documents that I was going to bring to your attention, being the updated table of response to the RFI requests. We think we've closed those out now, but if you require any further information in respect of those matters, please let us know. What we're calling the Day 2A version of the EMF it shows changes from the Day 2 version in blue highlight. They're mainly in the nature of changes to improve the readability and legibility of the document. There are a couple of other changes that we've identified relating to, in particular, a more explicit requirement to prepare a construction environment management plan, operational environmental management plan, and decommissioning environmental management plan, plans that had been alluded to during the document, but there was no consolidated requirement that they be prepared, and a couple of other tidy-ups that you'll see along the way. I'm happy to address you on those changes further if you like, but we're mindful that today's DECA's day and we don't want to take too much time in preliminary matters.
Yes, thank you. No, we're happy to we'll keep moving at this stage, but we'll come back to you if we do have any questions of clarification as well. Thank you. Mr. Tobin, is there anything in a preliminary nature that you need to raise for DECA?
Not from us. Thank you, Member Kendall.
Thank you. And anybody joining us online, I'll just take a moment to see if any hands come up. And I'm also just going to check that Member Joyner has been able to join us. Great, thank you. I can see that he has his hand raised. So, Member Joyner, lovely, thank you. Well, we'll move straight into submissions from DECA. Thank you. Thank you, Mr. Tobin.
Thank you, Member Kendall, members of the IAC. I wanted to start with a comment that really relates both to Parks and DECA, and that is that the specialties of those entities, Parks and DECA, is relatively narrow, having regard to the overall scope of considerations before the IAC. And we acknowledge that there is a broader range of considerations. Perhaps Parks Victoria has a broader remit and will be submitting on behalf of Parks Victoria in relation to the PSA. But certainly in respect of the submission you'll hear this morning on behalf of DECA, it is an input focused on energy and ecological matters, which needs to go into that balancing matrix that the committee will go through, with the principal approval at least being the PSA, which implements the EMF. The second matter, if we focus then in on DECA, is to acknowledge that the content of the EES, as augmented through the material presented in the hearing, is substantial. And it's a substantial body of work that you have in front of you, both in terms of primary investigations and in terms of literature reviews. And DECA acknowledges the extent of work that has gone into getting to this point in time. And you'll observe that DECA has tested some elements of the evidence, but not all of it. And that is intentional, that there are elements of the matters that are before you that DECA is that are within DECA's remit, that DECA is satisfied of. And to go for an example, we didn't ask any questions in relation to GDEs on behalf of DECA. We've elected, having made inquiries in relation to Boiler Swamp Road, not to come and ask questions of Miss Dunstan, albeit only a small portion of her evidence related to matters of emergency management. So all we note is that, by reflecting on that, is that there is DECA has sought to resource this case. It's sought to assist the committee by testing matters where it felt that the scope of materials before you perhaps didn't close out issues, or that there were particular matters it felt that should go into your assessment of the EES. And it has, and we ask that you have regard to those matters that we've raised to you, but also we acknowledge that in not raising some things, that is also indicative of the scope of work that's been undertaken by the proponent. Now, we'll come to this later in the submission in more detail, but there have been questions right from the point of the directions hearing and then throughout subsequent submissions about DECA's role and requesting either directions from the committee, or that DECA of its own intent call subject matter experts who have been behind me, feeding me information, and who have been working with the team who have undertaken and prepared DECA's submission. Suffice to say that DECA has had a long involvement in the project. It is a member in its environment sense of the TRG. It has tested material that has been advanced by the proponent over the multiple years through which the project has been prepared, and has had input in relation to both matters which DECA has sought to test and not to test through the matter. And so really, DECA, our headline there is that DECA's submission, or DECA's position and submissions in relation to this particular EES, are considered, and they have the benefit of significant technical expertise behind the submissions. So in DECA's submission to the IAC process back on at the end of March, and indeed in this submission, DECA doesn't come out and say that it supports or does not support the project. That's because, in large part, DECA's view, as I said at the very opening, is one that's narrow. So we don't have the full aspects in front of DECA, or at least that DECA are considering, as compared to the committee. These submissions seek to highlight what are some of the outstanding matters, and we've sought in the written submission to be explicit about where outstanding matters are those that are very much capable of being addressed through the EMF, for instance, through the BAMP, And so it's clear that they are, matters that deserve attention and appropriate drafting to ensure that they're addressed should the project be approved in an overall sense. There are 3 matters that are highlighted in the submission that we need to point out that are matters that still require further resolution and are not, I would say, not encompassed by what you've heard from the proponent in terms of the EMF and its day 1 documentation. Now, the first 2 matters relate to Boiler Swamp Road. Now, of course, Boiler Swamp Road is the location for the transmission line. You've heard the evidence of Mr. Galbraith in relation to tree loss and his opinion evidence in relation to tree loss and his articulation of a methodology to define the ultimate loss of trees through root investigations. DECA's position in relation to the Boiler Swamp Road vegetation loss is that, firstly, you ought not rely on the opinion evidence when you're assessing the impacts. You ought be appropriately conservative and make your assessment of the project on what's known today. And we say what's known today is the assumed loss, which has been calculated in accordance with tree protection zones in the way that the handbook prescribes it. So that's not saying that that goes one way or another, but we say that's the framework of the impact you should assess. Secondly, DECA submits that those native vegetation losses should be articulated in an updated native vegetation report. There's been some changes along the way. You might recall the evidence of Mr. Gibson where he's identified some other losses that don't need to occur, and that the number in that report should be articulated in the planning scheme amendment as the proposition for what needs to be offset for this project. And that's compared with an approach that's presently within the amendment documentation, which through the EMF leaves that for a process of determination under secondary consent once the root investigations have occurred. So that's the first 2 Boiler Swamp Road related matters, and I'll obviously address them in some greater detail later on. The third relates to the offsets and the security of offsets under the Victorian system. You have the benefit of the offset documentation. I think it's document 143 in the proceeding, which relates to the relevant offset sites. You might recall there was an update in relation to the federal site. And this is a matter that we think is very much capable of resolution during the process. But within document 143, it is stated that there are agreements in place in respect of some sites and letters of intent in place in respect of other sites. I think 2 have letters of intent, 3 have agreements in place. The normal course for DECA would be for it to have evidence of these offsets at this point in time, rather than merely the document that says that those positions are in place. As I say, I think that's something that's readily capable of resolution through redacted commercial agreements or the sort. But that's a matter that we think can be addressed in the running of the hearing through the balance of the case. Now, I think they deal with the preliminary matters and give us some sort of a roadmap. We then come to the written submission. I'm not intending to read the written submission to you. I'm just going to take you through it by topic. Section A on page 1 is substantially introductory. Paragraph 1 and 2 identify a number of definitions that are utilised through the through the submission. Paragraph 3 identifies the two arms of DECA who have informed the submission both to the process and to this submission today. The first substantive part of the submission comes to the DECA Energy Group submission, which is to be identified at paragraph 7 on page 2. You've had the benefit of evidence in relation to energy policy. You'll understand with regard to my opening submissions about what has been tested and what has not been tested is that DECA did not elect to test the evidence that was before you, notwithstanding it had submitted on the topic of energy policy. We've extracted the that part of the March submission that goes to energy policy at our paragraph 7. You'll see in the second indented paragraph that there's legislated targets to guide the decarbonisation of Victoria's economy. They are significant, 95% renewable by 2035. You'll see in the second to last paragraph on page 2 of the submission the description of a once-in-a-generation shift in how the state sources electricity. And that's very much consistent with the submissions you've heard and the evidence that you've heard in the matter. You'll see that there is a reference to the bilateral renewable energy transformation agreement with the government in order to support that transition. There's support from the Commonwealth Government to assist in that production. And then at section 1.2, there's a description of Victoria's climate action. We identify, and you've had submissions about this already, but Victorian legislation provides for decision makers to consider climate change impacts in two ways. First, decisions by the government should have regard to climate change actions. And in addition, we highlight the same amendments to the Planning and Environment Act that the proponent has highlighted to you, which came into effect in 2025, which require planning authorities to consider climate change in planning scheme amendments, where the amendment involves significant changes to the use of urban land or new development of land that may be exposed to natural hazards arising from climate change. So we think those submissions are, or what we say at paragraph 8 is that although it's been a long hearing, so far there has been no change materially to Victoria's climate policy over the course of the hearing. That's one thing that has been consistent really throughout. Those submissions that were made in the written submission in March stand in completeness as relevant to you moving forward in your assessment process. Section C of the submission turns to DECA's role in the EES process. Now, of course, as I've identified, DECA participated as a member of the technical reference group. At paragraph 11, we make the point that officers from the recap group reviewed and advised on material prepared by the proponent relating to native vegetation removal, threatened species risks, ecological impact assessment, Crown land implications, and alignment with relevant biodiversity policy and regulatory frameworks. DECA's advice was based on information available at the time to assist with the preparation of an EES that was capable of informing a robust and transparent assessment by you, the IAC. We make the point at paragraph 13 that, of course, that the Energy Group made a submission, which we've just gone to. And we say that DECA's approach at paragraph 15 was, through the TRG, was to identify and achieve an EES that was capable of being ready for exhibition. And we quote the DTP IAU submission, which identifies that is not intended to mean that the EES is necessarily perfected, but that it is at an appropriate level for submission. And you'll see that as they identify that some agency concerns that continued can be addressed through that process as well. But that also goes to some way to explain the further information that you'll have received prior to and during the hearing process. That's merely reflective of a fact that an EES at exhibition is a point in time assessment, and it's yet to be interrogated by the public, and it's yet to be fully resolved in a 360-degree way. Now, we say that DECA's involvement in the TRG process is important in at least three ways. Firstly, there's a number of requests from the community for DECA to produce technical experts to provide evidence. Its technical experts have been involved in informing the EES over a number of years. They have been involved in informing DECA's response and DECA's questions during the hearing. And so while we do not anticipate that that will satisfy the concerns expressed by the community, the committee should take comfort that it has the benefit, albeit not in the way that the community would like it to have been presented, but it has the benefit of the technical expertise that is held within DECA. And that's really bleeds into 17.2, where we say that DECA's submission to the EES was informed by technical advice, and these submissions support the contention that it's appropriately addressed its responsibility concerning the EES through each of its independent functions. The third point in 17.3 goes to an alleged or an assertion that the position of DECA is conflicted by virtue of its substantial portfolio that has a range of different matters, and pertinent to this case has responsibilities regarding energy policy and responsibilities regarding ecological matters. We say that the approach of DECA in making submissions in both of these matters, in both of these issues, either really suggests that there isn't a conflict of issue because there's been an even-handed presentation of the issues. In fact, it's been predominantly consumed by the ecological matters. And what we say in 17.3 is that there really isn't a conflict because of the way DECA is structured, with different groups running different elements of their work. Or if there is a conflict, it's been appropriately managed during the process to ensure that the committee has before it information concerning the information before it, which will assist it in assessing the impacts pertinently on the ecological matters, native veg and various species. The next section deals with the extensive material, both in the EES and that has been subsequently provided. There are a range of new materials that have obviously come to the fore through the process, both in the assistance of peer reviews, and for instance, Mr. Organ's peer review of the ecology, as opposed to Mr. Gibson and Mr. Venosta, who have been involved over a long period of time, but also through other material produced by DECA and DECA's research arm, the Arthur Riley Institute. For instance, the Southern Bent-wing bat flight study. Now, of course, the new material was not available to DECA through the process, and so it presents a challenge both to the committee, but equally a challenge to the proponent to adjust to the new material as it's been advanced forward. And I was looking through in preparing this submission the number of documents and the volume of information that has been filed not only by the proponent but by other parties, and presumably which will found submissions to be made to you in the coming weeks, of many different reports and many different studies. And it's an issue that cuts both ways. It's difficult for the committee, for the proponent, and for DECA and other parties to address that further information. What we say at paragraph 22 is that there have been some occasions where material has been tabled during the hearing and relied on by expert witnesses on the way through, and indeed you've had the benefit of some material from expert witnesses that has been filed after the completion of their evidence. Now, if there was a significant matter that we felt there was someone needed to be recalled upon, we would have made that submission. But it is a matter for you as to what weight you afford these various threads of information, and it's a position for the committee to determine what weight, and we say it must be evaluated carefully in those circumstances. And that has to do with the timing, the opportunity for stakeholders and for agencies, particularly for DECA, who has a lot of people behind the DECA officers here, getting across updated information such as the BAMP at short notice before the ecological evidence was certainly challenging, and for that reason we've sought and been granted that extension of time so that we can respond properly in terms of the EMF in due course. I think that really deals with that section. We then come to a section of the submission that deals with or addresses DECA's role and responsibilities. We really record this as a matter of having it on the paper what DECA is responsible for. Paragraph 23 is simply a description of what is in Chapter 5 of the EES. DECA must grant a licence pursuant to Section 52(1)(c)(f) of the Forest Act. You've been addressed on that by the proponent. It will have to deal with applications under the Flora and Fauna Guarantee Act, and it has road management responsibilities in respect of Boiler Swamp Road. And the project will, for the most part, be regulated by the EMF. It'll be approved by secondary consent, and to the extent that the EMF identifies certain plans as being to the satisfaction of DECA or being prepared in consultation with DECA, DECA accepts that that's part of its role, and it accepts the responsibility for doing those things in the form of the EMF that it'll advance. DECA holds statutory management responsibilities under the Land Act and under the Crown Land Reserves Act the administration and oversight in management of Crown land across Victoria. This affects Boiler Swamp Road within Kabobony Forest Park and National Park. It's the relevant land manager of the Forest Park, whereas Parks Victoria has the role in relation to the National Park. It's the fire manager for Crown land, which is a matter that we'll address principally through the EMF and also in this submission, and it manages the length of Boiler Swamp Road within the parks. And what that really goes to is paragraph 28, where the proposed infrastructure under Boiler Swamp Road must be demonstrated to its satisfaction not to compromise its land values, inhibit its operational responsibilities, emergency response, or create an unreasonable legal burden for maintenance, repair or decommissioning on the state. In the next section, from paragraph 29 to 32, we address DECA's responsibilities in terms of bushfire preparedness, and this occurs through Forest Fire Management Victoria. Boiler Swamp Road, the adjoining fire track network are critical to the fire response in this area. The routes facilitate rapid deployment, active suppression and safe egress during fire events. Obviously, the construction, particularly the construction process, is something that could affect DECA's work through Forest Fire Management Victoria. And what these submissions do later on is set out Forest Fire Management Victoria's position in relation to fire management and some relatively minor constraints on the way or on the timing of the proposed 9-month window of works for the Boiler Swamp Road transmission line work. So the proponents advanced a 9-month window, and DECA in effect will be seeking that those 9 months avoid, if you like, the peak of the peak within the fire season. We note in the following section that DECA, of course, also is a determining referral authority under the planning scheme in the context of permit applications. It's a recommending referral authority in respect of applications to remove native vegetation. Now, if we then turn to the, if you like, the substantive parts of the submission, DECA's position is informed by its expert review of the work that's been undertaken by the ecologists principally, so Mr. Van Oster, Mr. Organ and Mr. Gibson, and also its expert review of the BAMP. It has also reviewed Mr. Galbraith's expert evidence from the perspective of its level of compliance with the handbook, and that question that arose in the course of his evidence about what constitutes an arboricultural report that would justify not having trees within a field of assumed loss or having trees within as an assumed loss, which has been the approach taken through the application. So at paragraph 39, we say that areas of residual concern include the adequacy and enforceability of proposed mitigation measures, the scope and timing of commitments in the BAMP and the EMF, the feasibility of offsetting. Some elements of the expert evidence have raised further uncertainty or remain unresolved, particularly in relation to the southern bentwing back, the Brolga and the Australasian bittern and vegetation removal. Now, I think that the summary of these issues that we'll talk to is to be identified at paragraph 42. and they really that really sets out the issues that we'd like to address you on today. They are the construction activities, the fire management activities, native vegetation implications of the same, all along Boiler Swamp Road, the Australasian bittern, the use of advanced monitoring technologies, which is something I perhaps could have mentioned in opening, that there's a point of difference between DECA and the proponent, really on the way that they are framed in the EMF. DECA takes the view, the proponent's drafting as is read by DECA is that the EMF in respect of technologies suggests that it's something that should be contemplated, and DECA's reading of the material and the evidence is that the use of these technologies, and we'll use Identify It, but Identify It is a commercial operator. It's one option, but we're not saying that that is the option. But the evidence that DECA has heard, and DECA's position is that there should be a presumptive position unless you can do better with something else than the technologies. And we'll talk about why that's particularly important in respect of the Australasian bittern in a while. The BAMP, the matters regarding the application of the proposed annual contribution, they will only touch upon that briefly because we think that the proponent's submission has already addressed and overlapped with the approval mechanisms for some of the DECA matters in its submission, and we think that the revised EMF, the Day 2 EMF, and the proponent's submissions on how that might be managed seem pretty sensible, and will address any minor changes through the EMF process. The first issue below relates to Crown land. The highlight, we've spoken a little bit about the DECA's responsibilities, but from paragraph 47, we just set out what DECA is seeking in relation to that, and we'll reflect this in the papers, is that any approval include a condition requiring a submission of a detailed Crown land interaction and tenure plan, a requirement that all necessary licenses or consents are obtained before works on and access on Crown land occurs, but we think that's addressed in the material, and a schedule or equivalent mechanism to identify site-specific rehabilitation or access controls for Crown land to be incorporated into the EMF. And as we say, they're really EMF changes that we'll address on or before the 9th of July. The next section of the submission addresses the handbook. We've addressed this in correspondence to the committee when the handbook for the development of renewable energy in Victoria was advanced. The proponent has addressed the handbook to you in submissions. This section simply highlights that the handbook was released, it was consulted with and released with transitional arrangements. The proponent has confirmed that it doesn't intend to rely on the handbook, unsurprisingly, given the state of the project and how well advanced it is. And so while there are principles within the handbook, such as an emphasis on early stage avoidance, adaptive management, and structured monitoring, so there's a consistency between what is in front of you, DECA's assessment has neither taken account of the handbook in any way through its assessment of the EES or since the formal publication of the handbook, and we would invite the committee to approach its assessment on the same footing. Now, construction along Boiler Swamp Road within the Kobobini National Park, Chapter 3 of the EES describes the proposed construction methodology. we think read evenly, it suggested an approach that would see Boiler Swamp Road remain open throughout the construction of the transmission line. And we've extracted at our paragraph 55 some of the text there. Chapter 3 didn't provide great detail on the joint boxes, but on careful review within the Parks Victoria draft section 27 application, there was material in there quite similar to the material that has been prepared in document 110, which is the constructability report. So probably from the same consultant, or at least the same background documents. At paragraph 56, we note Mr. Galbraith's evidence includes recommendations at page 65 concerning the trenching for cabling, and this is premised on DECA's readings as preferring, where possible, a central location within approximately 1.5 metres of cabling disturbance falling generally either side of the centre of the road. We refer to the constructability report, document 110, prepared by Beyond Electrical Engineering, and that's where we see the joint box, which we've extracted from document 110, just for ease of reference there. And then we extract Miss Dunstan's evidence post the EES, which indicates that she's instructed that there will be limited capacity to maintain access for emergency vehicles along sections where construction of the transmission line is occurring. These have implications for native edge management and for fire management, and it's fair to say that prior and in making its submission, DECA had not fully appreciated the joint box construction requirements from its reading of the EES. Well, the further information from Mr. Galbraith and Ms. Dunstan indicates a change in approach, or at least a change in appreciation of the approach by DECA. Now, for these reasons, we wrote to the proponent seeking the further information. That is tabled document 363. And the proponent has responded within tabled document 364 with some detail, which is consistent really with the material in Appendix Z. DECA's considered that further information and sent it to the fire services part of DECA, and also considered it in light of the ecological issues. DECA is satisfied that the risk of reduced capacity to deliver emergency management, while not zero, that is, there is of course a risk, it could be managed to an acceptable level through the EMF, including prescriptions around the timing of works. This is premised on a no works period during January to February, where the highest fire danger exists, and a preferred no works period in the other months during the period from November to April inclusive. Now, you'll note, of course, that the period from November to April is, broadly speaking, varying from year to year in terms of the declared fire period. That period during which the fire period will be active. And we say that depending on the bushfire season, construction activities between November and April could be consistently interrupted, and the proponent will need to accept this risk in the event that, as indicated, the works cannot be confined to a May to October period. And we understand it's a 9-month period, at least as it's known at this point in time. The 13 June 2025 letter includes the following statements. The proponent expects that there would be conditions, would be requirements that construction plant and equipment be relocated, excavations, trenches made safe to allow emergency vehicle access during fire danger periods. The precise timetable would be determined during detailed design. There'll be a construction emergency management plan prepared in consultation with DECA and CFA that will address the procedures for managing bushfire risks. The processes outlined in 2.3 to 2.6 there to identify extreme fire risk responses could be managed through the EMF, noting that there will be extreme fire risk days throughout that period, and it's difficult to make specific recommendations at this point in time. So the other considerations are from DECA, all infrastructure under Boiler Swamp Road is required to be a minimum of 750 millimetres below the road. You'll see the materials in Appendix Z and in the constructability report both refer to being a minimum of 500 millimetres. We don't expect that there's a particular difficulty in that. But that additional depth must not result in additional environmental impacts through intersection with the notional root zone of additional trees. That depth of 750 millimetres is required for road maintenance purposes, while sheeting and grading don't require the increased depth. It can be that roads fail or require reshaping, and deep ripping is required to facilitate repairs following damage such as associated with significant rainfall. The EMF must include an approach for re-establishing the condition of the road to DECA's satisfaction. These are addressed presently under Management Measure TPO2, and we'll update some preferred text in relation to that for that particular matter. And the nature of the road unsealed will require a maintenance process to ensure that there's no compaction or subsidence over the trenching works, and there'll need to be an extended period of time associated with that. At the tail end of the submission, at Appendix A, there's some more detail that we've provided from the fire services arm, including some reference to proposed defect periods, and some detail that we'll be using to inform the EMF as it's advanced. We also put it on the record through the submission because it reflects the advice from the fire services arm. We thought it would be useful to have it recorded in the submission and recorded for the purposes of the proponent should the project be approved. And it then moves to the satisfaction of the EMF through conditions and the submission of plans. There's probably more detail in that table, or there is more detail in that table than you would logically have within an EMF. So we're not suggesting that the EMF is extended to include every matter there, but as I say, we're putting them on the record. Now, and at 68, DECA concludes it's satisfied that these are details that can all be resolved post-approval, subject to implementation of the recommended EMF. Now, DECA's original submission on the EES raised concerns regarding the project's treatment of native vegetation removal and the adequacy of avoidance and minimisation measures. And there is some persisting concern in that respect. Now, at 71, we identify that the NVRR, the Native Vegetation Removal Report, submitted as part of the exhibited EES, identifies 8.696 hectares of removal, including 228 large trees, and the 228 large trees are along Boiler Swamp Road through incursion of the transmission line into the TPZs, or notional root zones. The proponent's ecological evidence from Mr. Gibson suggests that this has been revised to 8.452 due to the minor refinements in the project design, including the retention of 3 patches of native vegetation along the over-dimensional vehicle access route. This updated information has not yet been reflected in a revised native vegetation report, and DECA requires that the report be updated to account for that. DECA's submission is that that's both the usual and appropriate level of information for this stage of a project, and it's appropriately referenced in the planning scheme amendment. Now, if I just pause there, the way that the approval documentation as it presently exists in the, what was it? Was it day 2A documentation, is that neither the planning scheme amendment nor the EMF will authorise any particular level of vegetation removal. The vegetation removal will be effectively determined through the, would be determined through the work that is to occur with Mr. Galbraith and the submission of a finalised native vegetation report at that period in time. Now, DECA advances that at this stage there should in fact be an approval for the removal of a specified amount of vegetation, albeit that specified amount of vegetation removal could be amended should the proponent determine to pursue the mitigation measures advanced by Mr. Galbraith through a post-approval activity. Many of the wind farm projects in Victoria are approved by a permit, ministerial permits, and it is very common for those ministerial permits to include, common, we'd say uniform, for the ministerial permits to include an authorised extent of vegetation loss. And so we don't think it's either unreasonable, and we certainly, or DECA submits it's certainly appropriate at this point in time, that this project addresses native vegetation removal on the same footing by identifying the vegetation loss that is approved through the process at this time. Now, it's true that if you go to EES processes for other projects, not wind farm projects, but for other projects, the approach identified by the proponent is not uncommon in terms of an approach where a presumptive vegetation loss is assumed through the assessment process, and that that presumptive loss is then finalised through the incorporated document and the EMF. So we're not advancing a position that EES processes don't, for various projects, don't adopt the approach advanced by the proponent. And so it's not unorthodox in that sense, but it's not the approach that DECA are familiar with in terms of the wind farm category of developments. And DECA submit that notwithstanding this is an EES process and not a permit, it's not the case that it should be necessarily treated differently just by dint of the approval process that it's advanced under. Now, if we then come to the substance of the debate around this issue, at our page 16, paragraph 73, the proponent's position in relation to the assumed loss of trees is that the methodology adopted in the Australian standard is unduly conservative, and that a number of trees, unspecified, previously assessed as lost, may now be retained on the basis of what we say is Mr. Galbraith's professional judgment, albeit professional judgment that is relied upon by Mr. Organ, in forming his views. He is, as we understand Mr. Organ's evidence on this point, adopted Mr. Galbraith's opinion in forming his view that the number of trees to be removed is, on his language, highly conservative. And I think that's the language of the proponent. We say, or Deaker says at the bottom of paragraph 73, that this defers a key measure of impact to another day, notwithstanding the project's been on foot for a significant period of time. Now, at 74 in the Assessor's Handbook, it's a matter that Miss Guild addressed you on last week, but it's been already updated very promptly to accommodate the revised Australian standard. And what we say about that revision is that nothing, just as Mr. Galbraith's addendum note said that not much turned on the revised Australian standard, the Assessor's Handbook takes the same approach, and it still says, and that's at the bottom of the quote at paragraph 74, that unless an arborist report includes otherwise, a tree or trees will be deemed lost if the encroachment of compaction and excavation into the notional root zone is greater than 10% or is inside the structural root zone. And we go to document 297, which is Mr. Galbraith's second addendum evidence. The proposed encroachment is considered moderate if it's greater than 10% and less than or equal to 20% of the notional root zone and is outside of the structural root zone. A project arborist shall be engaged to review the proposed impact and undertake any other investigation to address the factors and so forth. The point of taking you to this material is to say that we're still dealing in a paradigm where, even though it's now described as moderate, the test for the purpose of vegetation lost is the same. And I don't think anything different's been advanced in the case. We say that what you have in front of you is effectively opinion evidence of Mr. Galbraith and or deductive reasoning of Mr. Galbraith about the status of roots that might exist under the road. And Mr. Galbraith expresses confidence that you're unlikely to have roots under the road, or less likely to have substantial roots under the road, and that accordingly, by dint of the process of investigation of those roots, you'll get a reduced number of trees impacted. Mr. Galbraith, in his first addendum evidence, you might recall, undertook, I think it was a penetrometer analysis where he dropped some sort of weight to assess the density of the road and to determine, and that investigation was not successful on the terms of that evidence in actually assisting in determining where the root complexes were. So to be clear, then at this stage in time, what you've got in front of you is only Mr. Galbraith's opinion about what might occur or what might be the result of future investigations. Now, Deaker completely supports measures to minimise vegetation loss. So we're not saying, we're certainly not opposed, or Deaker is certainly not opposed to adopting a process that would investigate roots as proposed in the management measure and avoid them on the way through. But the assessment for the time being is to be premised upon what's known, and the assessment and we say the number that is inserted into the relevant approvals is also to be based on the presumptive loss of those trees at this time. Now, at 77, that's really a summary of what I've just said, that it's based not on actual investigations at this time. At 79, we say if the proponent is seeking to reduce its offset obligations by reclassifying trees previously assessed as lost, then this must be clearly presented in an updated NVRR with transparent cross-referencing to field-based data, and the proponent should demonstrate how those updated assumptions align with the guidelines, including a justification under Appendix 2 of the Assessor's Handbook. So, in summary, DECA supports efforts to reduce vegetation loss, but reiterates the need for transparent presentation, a finalised and consistent construction impact corridor, root zone investigations, and a reconciled and updated NVRR to identify final offset requirements based on actual and assumed loss. Now, that can occur post-approval, but it shouldn't be, that can occur post-approval, but what the Assessor's Handbook does is provide with a method for reconciliation where a project is assessed on number A, and then number B ends up being the ultimate extent of removal.
Mr. Tobin, I'm just not 100% sure of what you were just saying. Would you mind recapping that point?
DECA supports, firstly, DECA's first submission on this issue is that you should proceed on the basis of what we assume to be lost, and you should record what's assumed to be lost in the approval documents, should you suggest that the approval to proceed. DECA supports then that post-approval there could be revisions to that number based on the evidence and the mitigation measure that's been advanced by the proponent in whatever form it ends up, but that the appropriate process would then be for them to undertake a process I'll take you to in a moment about reconciliation under the handbook, to reconcile the difference between what has been approved and I guess you'd say what is ultimately, if that's a lesser number, what is ultimately the outcome.
Thank you.
And that's the point we make at paragraph 82, where we say, where we quote the handbook, where it says that some projects gain approval for the worst case scenario, native vegetation removal. And I think that's the way this project has been cast by the proponent in many respects, with a low amount actually removed during the construction and following final design. The worst case scenario approval will include offset conditions that require offsets to be secured prior to the removal of any native vegetation. If less native vegetation is removed than was included in the approval, offset reconciliation can take place as detailed in section C below. And section C at Appendix 8 of the handbook this is, so it's page 67 of the handbook, and the handbook is document 252 in the proceeding. And there's this process of reconciliation that's contemplated within the handbook, and the administrative steps are identified here. The project's been approved. The extent of vegetation removed is reduced. An accredited assessor confirms the actual extent. The applicant compares, approaches the approval authority, and the new offset requirements are detailed in the new NBR. And if agreed, the offset condition is amended. And that's then accounted through the credit process. So effectively, it's a process that's recognised. Now, we do accept that in this case, with the planning scheme amendment, by specifying a number in the PSA, that certifies that number, and there would be a process required to go through that. That is, you'd need to amend the approval documentation. But in the circumstances where, if this project is approved, it's approved pursuant to ministerial amendment, a subsequent ministerial amendment to update the approval documentation is completely possible. We then come to a consideration of offsets. The DECA position on offsets is that the offset strategy as presently prepared lacks certainty and compliance with section 6.4 of the guidelines, which requires that offsets must be identified and capable of being secured before vegetation removal commences. We've indicated there at paragraph 85 that there's a combination of first and third party offsets proposed. The position, as I advanced in the opening comments, is that, and it is articulated at paragraph 87, which is that there is an indication that the offset strategy considers properties that are either under option or have letters of intent. It seems to us in those circumstances that whether or not it's before the committee or it might be as between DECA and the proponent, that's a matter that can be satisfied before the close of the hearing suitably. We comment there on the need for an updated NBR, but I think we've already addressed you on that in substance before that, and the point being at paragraph 95 on our page 20 that the proponent has not yet met the regulatory requirement to provide a final NVRR or an offset statement that clearly demonstrates the availability and security of required offsets. So that's 11:14. I wonder if that's a convenient time, and then because we're about to turn to the fauna.
Yes, I'm happy. I'm just thinking it might be a good time for us to ask some questions of clarification if we have them. Yep. So I will ask if the members with me here have any questions. And if not, I can proceed. And if you have, thank you. We may follow up with some questions. I might run through just a few that are on my mind at this stage. And if you just give me a moment, so that I'm going to work backwards actually. So just on the point that you were discussing around the worst case scenario native vegetation removal approach that is sometimes taken, I'll use that shorthand description of it. If offsets can be secured, could you just talk to what you see as the disadvantage of proceeding with that worst case scenario approach?
The disadvantage?
Yes.
Well, that's really the way in which DECA submits it should proceed on the basis of the worst case scenario. We think that's the appropriate level of conservatism to approach. So if you like, as we understand the submissions of the proponent, are to seek to give you comfort that there is a high degree of likelihood that there'll be a lesser impact than what's been advanced in the EES. And our position is that no, what's been advanced in the EES stands until it doesn't. And you don't have technical information that should give you comfort to assess this project on any other footing than the assumed losses in the EES.
Okay. At paragraph 76, you've talked about the arboricultural evidence required, the arborist report that would satisfy the assessor's handbook. I don't know if you recall, I did ask a question of the experts regarding that, the standards for an arborist report of that nature, whether there are standards or any examples of an arborist report that would satisfy that.
What I might do is I'll perhaps directly after the break, I'll take you to, it's not like there's not a lot of assistance in the guidelines in the handbook.
Yes.
So I might take some instructions as to whether we can give you some advice on that. And in particular, whether it's a blow by blow, tree by tree, or whether there's, you might recall Mr. Galbraith's indication appeared to be that you could adopt some of the potentially worst affected trees and use them to, rather than assessing each of the trees along the road. That's how we understood his evidence, though the methodology is not yet finalised.
Yes.
Yeah.
No, that's fine. Only to the extent that you're able to advise. I'm familiar with the wording in the handbook, the general nature of it. Just a couple of other questions of clarification. The paragraph 59, where you talk about native vegetation management needs and access associated with that.
Sorry, which paragraph?
59.
59, sorry.
So there's the submission says the matters have implications for native vegetation management and for fire management. And then the submissions go on in paragraph 62 onwards to really focus on the fire management requirements. I'm just wanting to get a better understanding of the native vegetation management requirements that are being referred to in paragraph 95, whether there's something specific.
Sorry, I think I must have misheard you with the in which paragraph? My apologies.
So I am referring to a couple of paragraphs. I'll just start again. So paragraph 59 refers to the matters having implications, access having implications for native vegetation management and for fire management.
That's right.
And my reading of your paragraph 62 onwards, where the focus is on access for fire management purposes more specifically than for native vegetation management purposes. So I just was wanting to get a sense if you're able to share from a native vegetation management some of the access issues or the reasons why that access may be required.
Well, it's not the reference in paragraph 59 is really a reference to the matters that we've just been through, that the construction methodology will have an impact on the root zones of trees, and therefore will, by dint of that, have an impact on native vegetation.
Thank you. No, that's clear. Thank you. I might have been misreading that. And then just a final question for you about the deep ripping, not the depth, the requirement that DEEC is seeking for a 750 millimetre depth. And just if you're able to explain, is that a standard depth requirement for road maintenance for a road of that type?
I'll take some instructions on this is the 750 millimetres.
That's right, yeah. I'm just interested to understand that, the source of that. I can see that it's in the Appendix A attached to the submission as well.
It's I think it would be better described rather than maintenance. Perhaps the better term to describe it is renewal. which of course is something that occurs with assets from time to time. But we're in the context of a project of 30 years. It's entirely possible that during that period of time there'll be a need for renewal of the road over that period. But I'll get some instructions about the technical. I think what you're asking is what's the technical driver of 750 millimetres?
That's exactly what I'm asking. Thank you, Mr. Tobin. I don't have any other questions of clarification at this stage, so I'm happy to leave it there. Member Kirsch does have a question. I'll hand you to him.
Just one, thank you. Paragraph 47.
Mm-hmm.
It's under the Crown Land
Mm-hmm.
theme. There are 3 approval conditions that you've foreshadowed there. Just wasn't clear what the first and the third were and how they might be expressed, and that might become clearer when you provide your view on the EMF. But just reading them in that context, I wasn't quite sure what they meant.
And it might be, I mean, looking at 47.1, it is at a level of specificity that might or might not find its way into an EMF higher level driver, or whether it's a matter that DECA would ultimately adopt as part of when it requires a plan to be approved. So I don't have instructions on that or the final form of the EMF at this point in time. But effectively, in reading it, it does logically look like something that would form part of one of the plans under the EMF in relation to impacts on Crown land. And 47.3 is really the construction management things that will be dealt with, I expect, in the TMP, or the traffic management plan, or the construction traffic management plan that's been identified through the EMF.
So I think that just the remaining issue for us is there a recommendation or a request for us to respond to those in a particular?
No, you should. You can presume that when we advance our EMF, it will encompass sufficient controls to implement those matters.
Thanks.
Thank you, Mr. Tobin. We will break now, so we'll come back in 15 minutes and we'll see everybody then. Thank you. Thank you. I'll hand back to you, Mr. Tobin.
Thank you, Member Kendall. I had two things to inquire about over the break. The first is in relation to the 750 millimetre depth. I'm seeking some instructions about that, whether it's a particular piece of machinery that drives that depth, but all that's been confirmed for me is that it's the process of renewal that occurs from time to time that requires something deeper, and that whatever machinery it is drives a desire that they don't have to jump on and off different items of machinery or adjust machinery as they're progressing down the road when that occurs, if it occurs during the life of the project. But I'll come back to you if I get an answer as to the precise technical nature of that. The second matter you asked me to talk to was the whether there's some guidance that I could provide you in relation to the arboricultural report as it's referred to in the Assessor's Handbook. And the short answer to that is that there's not. To go one step further, the position of DECA in relation to this particular instance is that where that's undertaken, it should be undertaken on a tree by tree basis through that design. The reason for that is that we're dealing with a road which is it's a formed road, no doubt, but it's not a superhighway, and the extent to which the structure of the road under the surface is known or entirely consistent is unknown. And so DECA's position is that a cautious approach would dictate that we would actually assess the trees that are assumed to be lost through that deep penetrating radar along the entirety of the route.
Thank you.
That then takes us to the threatened species portion of the submission. That commences at paragraph 97 with the southern bent-wing bat. Now, obviously, it's a critically endangered species. It's listed under the EPBC Act and the FFG Act. There is 3 maternal caves, as you will have heard through the evidence, the smallest of which is within Portland. That maternal cave in Portland has also recently been I'll pop this up on the screen. I'm going to quote from Mr. Organ's evidence. If I pop this up onto screen, you might remember we asked Mr. Organ about climate change impacts and whether it was something that was a compounding impact, which meant that we needed to have more caution. And it's a point that the question was derived from that part of his report where he identifies that climate change is not to be treated as a background issue, but rather as a compounding pressure that could exacerbate residual impacts from the project. And in respect of the southern bent-wing bat, of course, he describes in his report an impact up where the young of the southern bent-wing bat in the Portland cave were, there was a, in Narracourt, there was a mortality event due to temperature changes in a particularly, I think, cold year in one year. So We just say that it's a species in that regard that requires particular caution in all of the circumstances. DECA's original submission raised concerns that the project could cause direct mortality and contribute to population level decline. Those concerns do remain, notwithstanding there is evidence from Mr. Gibson and the further information contained within the document 154, which is the foraging flights document, and document 175, which is the flight heights, the study by Bush et al. Now, we need to talk to document 154 and document 175. They are both pieces of work that have been contributed to by ARI, so contributed to by, in effect, that arm of DECA. It is correct. The evidence you've heard is correct to say that both reports, both in terms of flight height and in terms of the spatial distribution of the bat during foraging flights, the reports are consistent with the evidence that you've heard, right? So we accept that. That's true. What we urge caution about in respect of both reports is placing significant reliance or determinative reliance on those reports alone, given the sample sizes that contribute to the work that to the conclusions that are within those documents. And it was very good to have the benefit of Mr. Gibson and Mr. Organ speaking to this issue, but they did seem to place great weight in the outcomes of those studies. They are corroborative but not determinative, given the numbers. And so, at paragraph 99, the GPS tracking data set in document 154. It's a subpopulation of the bat which is estimated to be less than 2,000 individuals. 39 were GPS tracked in September, 69 were GPS tracked in February. That's a useful subset, but it's a small subset. 47 GPS units were recovered, and a further 9 non-commercial GPS units were recovered. And as we identified in questions of the witnesses, none of the no units were recovered from the Lower Glenelg National Park, which of course is to the west of the site, because of access difficulties getting into a cave to get those units. And of course, it's those bats that might have travelled to the west that might have influenced the data that you would get about where they're travelling in respect of the project area. You may recall that there was some emphasis put on the fact that in the document 154 that there were a very small number of flights that were tracked as being over the project area. And at 100, we say the majority of flights identified in the study do not intersect with the project. The data confirms that a small subset did. The flight study by Bush utilised that same data set and augmented it with other data. The manuscript is a preprint submitted for peer review prior to publication. The study is premised upon capturing and GPS tagging of, in total, 244 southern bent-winged bats with 93 retrieval units. And the study found that most flights do occur below 30 metres, which is consistent with the evidence that you've heard from the experts and consistent with the EES. That some southern bent-wing bats were identified at 60 metres or higher. For example, on 2 occasions, 2 separate bats from the Portland subpopulation were observed taking short flights above 70 metres, and that flight heights were generally higher in treed environs. And we've given you references to each part of the of the study where those are drawn from. And the study concludes that the bat is capable of flying to heights of more than 70 metres and potentially up to 144 metres based on the upper bounds of the model, above the model estimates, above the ground at times, and can change height from near ground to about 40 metres within minutes. These flight patterns have implications for the species given the complete overlap between renewable energy zones and their limited geographical range. DECA acknowledges that the data in the report suggests the majority of flights are likely to occur below rotor flight within the project area, noting that there is some uncertainty due to the fact that the southern bent-wing bat flights are higher in a treed environment. Now, while the risk may be lower because of fewer flights, there remains a risk. And we think that's fairly. Neither of the witnesses have indicated that there is no risk in relation to the southern bent-wing bat. We say in relation to the two studies that broad extrapolation from the data is not supported because of the limited sample size, the duration of the monitoring, and other limitations of the GPS tracking and modelling approach. It doesn't account for seasonal variation in movement. The data was collected over 3 to 4 weeks in September to October and February to March, and foraging patterns may vary at different times of the year. Obviously not when they're in torpor, but at different times of the active year. Limitations of detection in flooded or inaccessible cave systems. That's the reference to the Lower Glenelg National Park. And the broader conclusions of ARI research indicating that the southern bent-wing bat utilise the full landscape and do not confine their movements to narrow corridors. There remains a risk that the bat will intersect with the 60-metre high minimum rotor swept height. It's understood that the proponent accepts a persistent risk, noting its suggestion for curtailment measures. There will be a variation in the environment through the life of the project, with trees up to 35 metres at time, meaning that canopy may be as little as 25 metres below rotor height. The height is within the expected flying zone for foraging or commuting of the southern bent-wing bat. We say that evidence from mortality monitoring results in Western Victoria indicates that the southern bent-wing bat collisions have occurred in wind farms with varying rotor swept zones, at least in open agricultural settings. Now, of course, we do accept also that a difference between this wind farm or this project and other wind farms is the height of the rotor sweeping range being 60 metres above rather than a lower height. Given the status of the bat, DECA continues to support the proposed use of low wind speed curtailment as a potential risk reduction measure. Cut-in speeds are measured at the rotor height based on the evidence. Wind shear suggests that wind speeds are at this level or higher at hub height, and the ground level speed will be lower. That was the evidence you heard on the wind shear. So when it cuts out at 4.5, that means that the ground level speed will be considerably lower, and it can be expected that the bats will be active during that period of time. It's a measure, like everything else, it's not perfect. We refer at our paragraph 107 to the detection for carcasses, and we refer to technical note 10, which I've got as document 11, but I don't think that's correct. I'll get you a proper number for the symbolics report. $111, is it? Yeah, thank you. It's 111. Now, Symbolics are statistical consultants with expertise in wind farms. They suggest that further studies will be required to inform the extent of that the bat may be caught in trees within the estimated 100-metre fall zone, which would account for 96.4% of bats and 81% of birds. DECA notes that the issue remains uncertain given the work to finalise a mortality monitoring system has not occurred, or perhaps more particularly there that formative assessment of, well, can you detect, hasn't occurred. It's not surprising that there's not a full mortality regime in play at the moment, but some of that formative work hasn't been done. The proponent's commitment to well, I think 109 I probably don't need to read to you because we've now got more information from the proponent's submission. Of course, this when this went for approval, it dovetailed across the work that the proponent presented, I think, on last Thursday, or Wednesday rather. So Thursday, in fact. So we don't need to take you to that. And that really deals with those matters. So the summary of the DECA position is that the risk of turbine collision remains unresolved in pine plantation habitats and forest edges. The mitigation and monitoring measures have not been demonstrated in similar ecological contexts. You can leave 112.3 given the submissions of last week, and 112.4 falls within the same category. Now, having identified those concerns and the need for further refinements, at a paragraph 113, DECA does submit that the outstanding matters are all capable or within a scope that's capable of being resolved through the secondary consent process under the EMF and the BAMP. Now, the Australasian bittern is listed under the EPBC Act, the FFG Act. It's a cryptic, highly mobile wetland bird dependent upon shallow vegetated wetlands for breeding, foraging and seasonal dispersal. Now, you'd recall we asked the witnesses whether Long Swamp had appropriate habitat to the south of the project area, and both witnesses agreed that while Mr. Organ indicated that not all of it would, but agreed that some of it would, and Mr. Venosta also agreed with that proposition. Now, the EES acknowledged that the project may pose a significant collision risk to the Australasian bittern during the overlap between known movement pathways and the proposed rota windswept zone, including flight activity recorded over the southern pine plantation. Despite the presence of a resident population to the south of the project and individual records within the project area, the layout has stayed, was not revised. There's a reliance upon the buffers associated, effectively the Brolga buffers, to serve a like purpose. The assessment did not include empirical data on bittern flight behaviour or turbine avoidance, and nor did it propose species-specific mitigation measures, and DECA is not aware of successful mitigation strategies for this species at other wind farm facilities. The BAMP did not initially, at least, include targeted monitoring thresholds or adaptive management actions for the bittern. And while the EES recognised a risk of long-term decrease in the local bittern population, the mitigation hierarchy had not been meaningfully applied to demonstrate that the risk had been avoided or reduced to an acceptable level. A critical question for the Australasian bittern is whether the committee agrees with technical report C, is whether it accepts Mr. Venosta's position of whether there is a potential for a significant impact or satisfaction of the significant impact criteria for the Australasian bittern. And what we sought to do through the evidence that was presented by Mr. Organ and Mr. Van Oster for this was to use technical Appendix C, and more particularly the significant impact criteria assessment table in technical Appendix C, to highlight the difference in assessment as between Mr. Organ and Mr. Van Oster, and how they reached differing opinions in that respect. And our understanding of the evidence is set out at 118. Now, Mr. Organ questions the estimated population numbers for the species and considers that they should be approached cautiously. Mr. Van Oster adopts, and the EES adopts, a more conservative approach to population levels, and he adopts a precautionary approach in light of this, and in the absence of a population viability analysis. Now, Mr. Organ's evidence on this topic is identified at, or can be found at, document 84, page 54, and what it talks about, and I'm not going to read the whole extract to you, but I want to highlight for you what he says, and I guess get you to take a note of it when you're considering the population, because what's apparent from the population estimates for the national population and the population estimates that he identifies at his page 55 for the local population is that we've got a series of what are overlapping numbers. Mr. Organ's numbers are not wholly different to those advanced by Mr. Van Oster, and likewise the other way around. Now, if we take the example of the national population, recent studies significantly improve the understanding. Global population at 2,000 birds, 1,300 birds in Australia. Now, the biosis assessment relies on earlier estimates, which place the Australian population at approximately 1,200 individuals, or 650, with a range of 650 to 1,750. And as Mr. Organ fairly notes, while the two estimates are broadly similar, the more recent figures provided by Herring and adopted in the National Recovery Plan reflects refinement on updated survey methods, satellite tracking, and habitat occupancy modelling. The updated recovery plan estimates the national population at approximately 1,300, and with a range of 750 to 1,800. Now, recognising the increasing role of inland agricultural systems. So we just pause there for a bit. The difference in population in relation to the Australasian bittern seems to be that on a national level, Mr. Organ considers that the 1,200 with a range of 650 to 1,750 is unduly conservative, while the other figure at 1,300, 750 to 1,800 is more appropriate. And it just struck Dika at looking at the difference in the population material that informs the two positions is that they are quite close in terms of that difference. And then there's a similar discussion in relation to the localised area. There's long swamp and pig swamp across the border in South Australia, estimated to support up to 15% of the national population, assuming an updated national estimate of around 1,300 individuals, approximately 195 associated, but the methodology is unclear. 15% appears to rely on presence data rather than verified density and should be treated as preliminary and potentially inaccurate indicator, with the actual number possibly being lower depending on the seasonal use patterns and habitat availability. And later on, Mr. Organ says that the broader statement that Long Swamp and Pink Swamp collectively support 15% of the national population should be considered cautiously. And then Mr. Organ goes on to talk about other techniques that can be used to identify and verify numbers, and he talks about how that should be part of that next process that's coming up should the project be approved. Again, the submission is that properly characterised, on everybody's evidence, there's uncertainty about the population, as indicated by the need to do further monitoring as part of the BAMP and the preparation, if you like, for the project should it be approved. And what we say about the numbers is that the numbers are very close. While Mr. Organ founded strong conclusions, or what appeared to be strong conclusions based on his review of the population data, they're not manifestly different population numbers. We note at our 118.2 that Mr. Venosta considers that the impact of the project may interfere with the recovery of the species. Mr. Organ does not, and they are the two matters that go to the EPBC Act. Both experts agree there's appropriate habitat. Both experts agree that local flights for foraging would have lower flight heights, a matter that Council for the proponent made the point about last week. Both experts accept that longer flights may occur over the project area. That's not a given, that's a possibility. Both experts agree that the bittern can fly at a height which intersects with the turbines. We understand Mr. Organ's evidence as relying on the implementation of avoidance measures. And both experts also, and I won't dwell on this, are comfortable with the use of that Block 7 under the offset management plan in document 143 as a potential offset. At 120, we say DECA maintains there's a residual risk and to the bittern it remains high, and considers that the BAMP should address how the uncertainties would be managed and what measures under the mitigation hierarchy would be used to resolve the risk. The available evidence acknowledges the potential for long-term decline, at least insofar as the EES and Mr. Venosta are concerned, due to turbine collision risk. And we say it's a species with low overall numbers and therefore a high sensitivity to disturbance and no history of successful mitigation at wind energy facilities, though we've heard Mr. Organ express a degree of confidence that the use of Identiflight or a similar would be an effective measure for the bittern. And I won't put it up on the screen, but there is a similar discussion in document 67. Perhaps a bit less robust, but it's certainly something that Mr. Venosta has also contemplated or commented upon in his evidence. At 122, we say that DECA continues to support the findings of Appendix C to the EES, which concluded that the project may have a long-term decrease in the size of the local Australasian bittern population. And that is of particular concern given the species' reliance on the broader Discovery Coast wetland network as a key regional refuge. DECA submits that the risk of population level impact remains unresolved and must be carefully considered in the IAC's assessment. Now, we spend a little bit of time here discussing Robbie, the quite famous Australasian bittern, and the bitterns in the rice project. What we think is clear from this is that there is limited data that's available. We haven't got the resolved data that's soon to be released as to what comes from the bitterns in the rice project. We don't have a multitude of birds who have been tagged through that project. But what we do know is that there is activity to the north of the project. There is activity to the west of the project out towards Pick Swamp, and we know that they've actually gone to Pick Swamp. But we can't say whether in going between Long Swamp and the Riverina, they use the project area. So it's just something that we don't know. We've certainly got no authoritative evidence to say they do. We haven't got evidence to say they don't. At 124, we pick up an issue that Mr. Organ cited the communications from Mr. Herring about flights below 70 metres. And he states in his evidence that these findings indicate that migratory movements within relatively flat landscapes such as the project area in southwest Victoria are generally undertaken at lower altitudes. And you remember we called for, or I think Mr. Organ indicated that he would provide what became document 303. We just invite the IAC to read document 303 and form its own conclusion as to whether it provides a good foundation to draw that conclusion. I'll leave it there. In relation to the, at 126, we note the lower localised flights within the area, and that being the evidence of Mr. Organ and Mr. Venosta. We don't have what DECA would describe as robust movement data for the species. So we accept that's the evidence before you, but we don't have what clear evidence that that's the case. And at 127, DECA therefore concludes that there's a risk of both local and broader migratory movements across the site being impacted by the project is plausible. We talk at our paragraph 128 to the difference between Mr. Venosta and Mr. Organ on significant impact. And we note that the offset strategy at 129 for the bittern remains broad, conceptual and highly uncertain. DECA supports exploration of compensatory measures, including wetland restoration and habitat enhancement. There is some lack of detail, though, in relation to that offset because we haven't got a mortality estimate to guide offset design. The restoration site is within 7 kilometres of the turbines, and we say, or we suggest that it might expose new individuals to ongoing risk. Now, you'd note that DECA put that question to both witnesses, and they both gave evidence that we footnoted that they considered that the benefit of the offset site would far outweigh any increased risk if there was any. And there's some other details to be worked out that we identify there at 129.3 and 129.4. The point, if you like, those points are summarised in the second sentence of paragraph 130, where it said that a lawful and proportionate offset response requires measurable outcomes based on a defined residual impact, and that work's yet to be done. In the absence of that work being done, which is proposed through those surveys which are to occur prior to construction, reliance on post-construction mortality payments or negotiated compensation is not a substitute. So we set out DECA's conclusions, and of those conclusions, we just highlight under 132.3 that in relation to the bittern, the use of technologies is supported by DECA. There was direct evidence from the experts on that it would be effective, particularly Mr. Organ, who seemed to be the, if I can call it, the lead expert or the person who had done the most work in relation to the use of these technologies. He expressed confidence that it could effectively identify the bittern. And as we'll discuss later on in this submission, the use of those technologies is not just about curtailment and having an impact on the running of the project. Those technologies could be influential in understanding how species such as the bittern utilise the area. And the reason for that is a survey over a period of time. We know there's a population there, but a survey over a period of time may or may not capture use of the project area, whereas the sort of lengthy survey that can be achieved through the use of technology will provide a better basis upon which to conclude whether curtailment measures are required, whether the risk is a real risk, based as it is expected to be based on what we presently know. So if we move to the Brolga, the DECA's concerns with the Brolga are relatively confined, as illustrated by the limited questions of the expert on the issue. DECA, first of all, responds to the suggestion that it provided approval for the proposed buffers advanced by the EES by the proponent, advanced in the EES by the proponent under the interim guidelines. The interim guidelines refer to DECA under its former name DSE. Again, they're very lengthy. There's probably 2 or 3 names ago. And what the interim guidelines state is that DSE contributes to the planning process by providing advice and expertise on environmental matters. The Brolga guidelines play a key part in DSE's current approach. These, in the second paragraph, the guidelines provide for turbine-free buffers. And at the end it says proposed buffer distances should meet with the satisfaction of DSE. And then in the next paragraph, Brolga breeding and non-breeding home ranges are likely to vary with local habitat quality and extent and seasonal conditions. Unless site-specific conditions can show a high level of confidence, the size and shape of home ranges for a project, then DSE's default breeding and flocking site home ranges should be used for the project. Proposed site-specific buffer distances should be agreed to by DSE. So each of those quotes describe the role that DECA has assumed through the TRG process in interrogating the work advanced by the proponent over the multiple years of the TRG process. DECA does not provide a statutory approval. It doesn't give a permit under the guidelines to do something different. It provides advice, and the interim guidelines themselves are advisory rather than statute, and DECA provides proponents with feedback on proposals advanced in relation to their application, and that was through the TRG. So all of that is to say that this is really a response that the committee asked to one of the questions from submitters, is that's the role DECA played. DECA played an iterative role in assessing the work advanced in respect of the BROLGA by the proponent, and provided advice on the proposed BROLGA buffers that you now see in the EES, to the extent that you can see that DECA has not sought to challenge that aspect of the EES. It can be appropriately inferred that DECA is satisfied with those elements of the EES that go to the buffers. Now, there was one, or the issue that we did ask some questions of in evidence related to the application of MMBD01 as it applied to the substation works, and DECA was expressing a concern about the works during breeding season, and the answers of both experts indicate that potential disturbance is unavoidable on their instructions about the extent of work. We agree with the submissions you heard from Mr. Chessel last week, that the BROLGA offset assessment is to be undertaken now, not during the running, which was the evidence that Mr. Van Oster gave if there was an impact on breeding because of the substation works. And that's what we describe at our paragraph 138. Now, at 140, we observed that Mr. Van Oster's evidence considers the 3 transmission line options. DECA agrees with Mr. Van Oster that the southern option is the most favourable for the BROLGA. The collision risk model predicts a further mortality with the overhead options over the life of the project. This information introduces an additional potential risk to the BROLGA at this location that wasn't accounted for previously. However, there is uncertainty regarding which power line option will be used and therefore the overall collision risk. If a different option was chosen, and the overhead power line was then to go through the BROLGA breeding buffer, DECA would consider that outcome to no longer align with the interim guidelines and agree with the evidence provided by Mr. Organ and Mr. Van Oster that additional mitigations would need to be applied and the CRM would need to be recalculated and added to the BROLGA compensation plan. That is not to say it's a stop sign, but it's just a factor that needs to be updated on the information available from the information available in the EES. Mr. Organ stated that the exception to this is the proposed overhead transmission line shown in figure 11.2, which is located to the south of Portland Nelson Road, and that's his description of that buffer. So we've adopted Mr. Organ's recommendations as we set out at 143, and DECA is satisfied that all outstanding matters in relation to the BROLGA can be addressed through the EMF. Now, they're 2 of the meteor species. We'll move through a little bit more quickly from here. The next species is the southeastern red-tailed black cockatoo, endangered under the EPBC Act and the FFG. We've got a species distribution restricted to southwest Victoria and southeastern Australia, with core habitat characterised by the presence of the Bolokan stringy bark trees. DECA's original submission identified ongoing uncertainty regarding both collision risk and potential population level impacts associated with the species. Mr. Gibson's evidence accepts that the cockatoo may fly across the project site, including movements from the below habitat to the east towards Discovery Bay coastal strip. DECA put that this may be for access to water to both Mr. Gibson and Mr. Organ. And you might recall that Mr. Organ didn't think this was a likely outcome. He rejected that proposition that we put to him. Mr. Organ's evidence attempts to exclude multiple VBA records in relation to the cockatoo activity south of the project area on the basis that there's no breeding or nesting occurs in these locations. DECA says that may well have been for access to water, and further, DECA's approach to VBA records is that they should be given weight while they are on the VBA, not evaluated on a site-by-site basis until they're removed, because with the VBA there is a process for putting things on the VBA and there's a process for removing them, and you should take account of things that are on the VBA until they're not. You'll see that DECA accepts at paragraph 150 that movement across the wind farm may be infrequent. But the concern that DECA have is that given it's a flocking species, that even a single turbine strike may include multiple individuals. There is Mr. Organ's risk profile relies on flight height studies conducted in the Wimmera. In an appendix, they're described in an appendice to Appendix C. Movements were estimated visually and including height in that case. We say that this evidence of Mr. Organ assumes that the stringy bark and pine plantation habitats are equivalent in height and structure, when in fact pine plantations, where they exist through the rotational plantation environment, may be significantly taller than stringy barks, and they may have a different structure. When you go to the flight height study for these, it indicates that it's not clear whether they flew through the trees or over the trees when they were assessing their path. Now, ultimately, this is a species that can be again managed through the BAMP, which should include targeted survey and monitoring for cockatoo presence, movement and flocking behaviour prior to and during operation, and then with any confirmed presence triggering adaptive mitigation measures. The next species is the grey-headed flying fox. DECA satisfied the project will not result in significant impacts to the grey-headed flying fox. At 155, we note that in a theoretical sense, curtailment measures described in the BAMP may assist with reducing potential mortality of the species. It is much larger, more robust, and more likely to fly in a range of wind conditions. But any remaining matters can be resolved through the BAMP. We then come to the migratory species, Latham snipe, the OBP, the blue-winged parrot, and the white-throated needletail. Now, in terms of Latham snipe, unlike other migratory shorebirds, is likely to move directly across the project area. And DECA observes that the EES and Appendix C acknowledge the presence of a residual risk and that local flights may result in collisions with turbines. DECA also notes that Mr. Van Oster's expert evidence accepts that residual risk remains and there's assumed to be a potential for collisions to occur. He also refers to a potential benefit from the Brolga buffers in the project area. So the evidence supports DECA's concern that there's a residual risk. And DECA observes that document 229, the revised BAMP, and this isn't changed by the document 380, the updated BAMP document, that that the BAMP now provides explicitly for ongoing monitoring for the snipe as one of the species identified in Table 4 of the BAMP. And DECA also observes that monitoring is proposed and that the draft BAMP contemplates smart curtailment technologies if the species is identified as at risk through the monitoring efforts. And again, this can be managed through the BAMP. With the OBP, of course, what we're dealing with is a very small population, a population in the wild of about 170 birds. One example of the OBP being identified during the surveys, not in the project area, but outside of the project area. Now, the question mark in relation to the OBP is identified through paragraph 166, and you'd recall Mr. Organ gave evidence that the OBP can be found with the blue-wing parrot or fly with the blue-wing parrot. Now, what we're referring to there is a document that we handed up that ultimately became document it is document 340. And document 340 is the Cattle Hill Wind Farm annual review. And document 340, which I'll pop up on the screen, at its page 14, doesn't quite run to pages, apologies. Sorry, it's page 18. Identified, well, two matters so that we don't have to come back to this page. One is the fact that the, I think it's identified, it is identified that's used in that particular technology used there, was able to identify a range of species that might not necessarily be suitable for curtailment, but it could identify flights as a useful monitoring methodology. But it identify a range of blue-wing parrot mortalities at that location. That caused us to ask Mr. Organ about whether that might mean that the OBP could be at risk. And we understand that the evidence is that the blue-wing parrot demonstrates different flocking behaviours in Tasmania compared to when it's in Victoria. We can't identify that. That's the evidence you've got to evaluate. And that's the only evidence you've got. So in DECA's view, in relation to the OBP, it should also be noted that in relation to the OBP that, as we say up in our paragraph, (159), in respect of the Latham's snipe, the Latham's snipe is the one of these birds that is very likely to go across the project area, or is likely to go across the project area, is the language we've used. The orange-bellied parrot, of course, is less likely to use the project area, given the habitat and the saltbush and the like that it feeds off. Ultimately, these are matters, or the management of the species can occur through the BAMP. In respect of the blue-winged parrot, the only comment that we've got, or substantive comment that we've got in relation to that, is at paragraph 170, where DECA has some concern that the collision risk model may not adequately account for the flocking behaviour. Of course, you've got that evidence of Mr. Organ in relation to that. But again, that's the sort of matter that can be addressed through the BAMP process should the project be approved. And then in relation to the white-throated needletail, DECA's original submission identified a high degree of uncertainty regarding population level impacts. At that time, DECA had noted that there were no known mitigation measures. The EES proposed to investigate the use of smart turbine curtailment within the BAMP, and DECA submitted that the high uncertainty and known migration behaviour of the species meant that the residual risk remained and warranted a precautionary and evidence-based approach. We understand that the evidence doesn't support a high a population level impact, of course. So that's the evidence of the two relevant experts on that. And we also just refer to, as I did on page 18 of document 340, that automated detection might be a way to minimise risk to the species, and that's something that should be considered. So we then come to the BAMP itself. I think the first thing to say about this compared to the EES that DECA hasn't had an opportunity to comment on is that DECA supports the proposed structure or stage structure of the BAMP. So that was a substantial change between the EES and the revised version. And at 175, we note that, of course, it's in draft form and lacks detail in certain respects that would be included within a BAMP capable of approval, but it's not held out to be the finalised work, with all experts acknowledging there's further work to follow. And the proponent has set out the further work that it considers necessary to do. So in relation to at 178, the deferral of investigation of key species is a matter of some concern for DECA. So once a project's approved, the ability for pre-commissioning investigations to influence the operation of a project may be limited depending on the nature of the species. And what we say there is that surveys at that stage can only consider what to do rather than whether to do it. Mr. Van Oster's statement recommends additional pre-construction utilisation monitoring for a range of species to quantify the potential level of effect on the Australasian bittern to establish baselines for comparison with operational monitoring, and the other species identified are the bittern, the brolga and Latham snipe. DECA asked the question of Mr. Van Oster why such surveys, which could have been done, were not undertaken as part of his assessment process, and the response and the evidence you've got is that there exists significant certainty in the material advanced, and so that's the evidence, and Deeker's concern has been responded to in that way. Deeker, of course, is not opposed to further surveys via the EMF and the BAMP to inform the mitigation and offset strategy. Deeker supports the proposed operational monitoring suggested in Table 4 of the BAMP. Now, that's document 380. Might be worth popping that up. Oh, no, that's not document 380. It's document 228. Sorry, 229 is the actual BAMP. And so what Table 4 identifies are bird and bat pre-commissioning and operational utilisation monitoring. And you'll see that Table 4 identifies of those species which Deeker has expressed particular concern about: the southern bent-winged bat, the Australasian bittern, Latham's snipe, both the OBP and the blue-winged parrot. Each of those key species are identified with a list of monitoring objectives and potential methodology. Now, at paragraph 181, Deeker submits that if further surveys are to be undertaken, these should be undertaken using a reliable methodology, such as a technological system like Identiflight, which has the ability to see many more flights of birds than a human can. Provided an acceptable form of EMF is approved, Deeker is content to manage this through the EMF. So, for instance, at 7.1.1 of the BAMP considers the use of mathematical models to inform studies and outcomes. This alone would not be satisfactory to Deeker. Deeker understands the evidence of the ecological witnesses is that the project should be using available technologies such as those described in some detail during the ecological evidence. Now, you'd recall the way the exchange went was that I put to each of the three witnesses whether this was a project that should be using those technologies. In each case, I understood the answer to be yes. In re-examination, Mr. Chessel put the proposed wording of the EMF to each of the witnesses quite fairly and said, well, would this satisfy you, in effect, as to the use of technologies? And of course, that's the wording that's premised on a position that requires consideration of the use of those technologies. So we accept that you have the questions that were question and answers that were put by Deeker and the responses from the witnesses, and you've got the responses to Mr. Chessel's re-examination in that respect. But we just ask you, when you go to the evidence and you go back to, for example, the evidence of Mr. Organ, and I refer you to page 99 of document 84, which is Mr. Organ's evidence on an automated avian detection and curtailment system, and the evidence that Mr. Organ gave orally in relation to the use of these technologies. As Deeker heard the evidence, this is the gold standard methodology, and it should be presumed to be used in this case. And so rather than have an approach where it's considered subject to the various matters that are currently set out in the EMF, Deeker will advance drafting that says it should be presumed by default unless there's an alternative that will meet the measure, that will satisfy Deeker. Now, it may be at 184, because cost is a matter that's been raised as a concern in relation to the use of these technologies. And at 184, Deeker does observe that with the BAMP being an adaptive plan, it may be that the use of technologies early in the life of the project, that is, at the time when these pre-commissioning surveys are undertaken, can inform selective locational application of the technologies, or even provide a basis for conclusions that ongoing use of technologies can be minimised. But that's the presumptive. You start with it. You've got the bittern. It's a species that's in low numbers. It may well have a significant impact depending on what the Federal Minister ultimately finds under the EPBC Act. We say that the best evidence should be advanced in relation to those pre-commissioning surveys. And we set out our 185 what the EMF said at that point in time. Now, we set out, there was an exchange that we've just sought to clarify in 186 where I had an exchange, or perhaps it wasn't an exchange, it was Mr. Organ just provided evidence that Identify could go to 30 metres. The material that's been submitted in document 224 suggests that it can go higher than, or can go up to 40 metres, which would mean that it would have coverage over the pine plantation even at its highest. That also addresses some concerns that were raised in questions by some of the other submitters to the process. So I think that deals with everything we need to say about the use of technologies. The last issue under this section of the submission is mortality monitoring. And the conclusion there is that between the semantic work and the updated section 9, this is at my paragraph 190, between the semantic work and the semantics work and section 9.4 of the updated BAMP, in the final sentence, Deeker is comfortable that the material advanced is sufficient for it to have confidence that the BAMP can facilitate a mathematical and practical basis for appropriate carcass searching. Mr. Organ refers to an independent environmental auditor, and that's Deeker is supportive of that suggestion, but notes that it's not, on our reading at least, unless we've missed it, part of the the revised draft BAMP. And then I don't need to take you to paragraph 192 because we've now got further information on the application of the funds proposed by the proponent. In respect of the EMF we're going to push submissions on that. We've just foreshadowed the matters that we think may need to be addressed through DECA's drafting. And after today, we'll pick up that drafting again and get working on providing a version to the committee. And then we have our conclusion, which I think it can be summarised as such. There is no doubt with a project of this scale and in this environment, there are residual risks. That's an inevitable product, and indeed projects that have been led in more benign environments, mortalities occur even there, suggesting that there's always going to be a level of risk. But as you'll have heard, that in terms of the species of concern, DECA is satisfied that there is an ability to manage those through the BAMP. But that's a view that's premised upon the application of technologies, at least presumptively, unless DECA can be persuaded to the contrary through the endorsement of the BAMP. In relation to native vegetation, there is some other residual matters that remain of concern, those being the extent of native vegetation removal. Not that the upper limit has not been appropriately cast, that is the presumed loss, but just that the mechanism proposed to not identify that number in the approval documents, and I guess DECA having satisfaction that the offsets are secured, are the residual matters in relation to native vegetation and Boiler Swamp Road. So they are DECA's submissions. It's 12:54. Timing's worked pretty well. Just enough time for some questions.
Thank you, Mr. Tobin. Well done. We do have some questions, and I'll hand you to Member Wilkinson to run through for starters. Thank you.
Thank you. And I'll start by going back to your paragraph 113 in relation to the BAT.
Yes.
So you say that DECA submits that the outstanding issues can be resolved via secondary consent in consultation with DECA. Could you just sort of briefly outline how you would see those matters being resolved?
How we see those matters being resolved?
Through those secondary consents.
Yeah. So there's a proposition that's already advanced through the BAMP of the use of curtailment measures. There are the secondary consent mechanism will involve the preparation and submission of a plan, which will examine the ongoing monitoring and effectiveness of those in conjunction with the finalisation of a mortality plan. And then it being an adaptive plan, it will necessarily have to adjust and, if you like, cut its cloth. The proponent will need to cut its cloth according to the outcomes of the implementation of the finally approved plan. I guess it's that adaptive nature which will ultimately define the measures of curtailment and so forth.
Yeah, I asked that question because identified or similar technology is not going to help us in this case to better understand those, both the flight movements across the site and the abundance.
Yeah, I agree with that. I think the evidence was pretty clear that identified will not be of assistance, or is unlikely to be of assistance with species like that. So I agree with that assessment.
Yeah. Well, okay, I'll turn to Brolgers. Now, Document 285, which I'm sure you've seen, is a internal memo from DECA, which was kindly provided to us by Smitter 82, and in that it canvasses options for the for the width of broader buffers. Looks at the sort of the science and just what would be necessary to provide the level of protection that that DECA considers is necessary. Now, the recommended option there, which is accepted, is for a 600 metre buffer plus the 300 metres disturbance buffer, so 900 metres in total. Now that, of course, is what we see in the handbook, the Renewable Energy Handbook. The handbook, of course, is as you've covered today, is not does not have to apply to this project, but the buffer that's being proposed here, of course, is very much consistent with the handbook. So my question is, can the IAC take that document 285 to represent DECA's rationale for why that the buffer that is adopted in the handbook, why that has been selected?
That sounds like a question I'm going to have to take on notice. It'll come as no surprise, Mr. Wilkinson. But I'm just going to state the question back to you so that I can respond to you promptly after the break. Is the substance of document 285 a description of the logic that sits behind the adoption of the measures in the handbook?
Yes, that's correct. Yep.
Well, it's capable of a yes or no answer, but I'll see what comes.
Yeah. Move to the red-tailed black cockatoo. You say in paragraph 148. So I'm just getting through to that paragraph. That Mr. Organ attempts to exclude multiple VBA records on the basis that no breeding or nesting occurs in those locations. But if we look at Mr. Organ's evidence, document 84, and table 4 is where he goes through those records and provides his assessment of the reliability of those. That the reason he excludes those records would seem to be more about the questions over the accuracy of the locations, where some things perhaps seem to have been missed up a bit. So it's basically around just the reliability of those records. So is that really a more accurate reason for why he's rejected those records rather than whether breeding or nesting occurs?
Just let me go back to that part of his Yeah, I think that's a fair summary, what you put there, Mr. Wilkinson. Yes.
Mhm. Right. Okay, just a question about the reporting requirements that are written into the BAMP. The one of the things that's come through some of the submissions, the expert witness evidence, is and also in the studies that have been done by ARI, is that it's been very difficult to really compare pre and post operation to compare sort of records of abundance of species. Yeah, of course, a whole range of data limitations, and including the proponent has made the statement in the EES about trying to address cumulative impacts on species such as the white-throated needletail. Is DECA satisfied that the reporting requirements in the BAMP are sufficient to overcome those limitations from previous projects?
I'm not sure that the BAMP has been reviewed in a specific way to see that it addresses the post-construction mortalities study. But of course, the BAMP that we've got at the moment is a BAMP that's a draft BAMP that will be prepared and documented to DECA's satisfaction, and it's premised upon undertaking further pre-construction work. So it's a draft document. So I just would say that the measure of the current, I would exercise some caution in saying that the current BAMP needs to be the complete answer to all matters, or the current draft BAMP. It's not even a BAMP at this stage, because they're matters that can be addressed. And of course, I took you to table 4 and the idea that there would be pre-construction surveys to identify that. Now, one of the difficulties with the other study is that the DECA conclusions were premised, if you recall, from one of the earlier exchanges on material that we couldn't release because it had been obtained subject to confidentiality. And so we can't speak to what the comparative, how comparatively robust the material from each of those other examples is. I guess the only way I could answer it fulsome is to say we've got a draft BAMP and we've got an agency who have recently released something about the need for there to be or about some of the inaccuracies between pre and post measuring. So one would assume that it will be a matter of focus in any approval should the project proceed.
Yeah, and the new guidelines do provide some detail about monitoring requirements and recording mortalities.
That's right.
Yeah.
And as the submission said, in relation to mortalities, DECA were quite explicit at their paragraph under the BAMP section that they were satisfied that at 190, DECA were comfortable that the material advanced is sufficient for it to have confidence that the BAMP can facilitate a mathematical and practical basis for carcass searching. So that end with the pre-monitoring. Yeah.
Okay. Can I just turn to your comments about technology, the identifier or similar? There are two basic functions of that technology which are very much intertwined. One is it can be used for monitoring, so baseline monitoring, and determine whether what movements a species is making across the site. Then the other is using it for active curtailment, where it's very much linked to if the species is detected, then curtailment measures come into place. Is when Dika says that it wants the technology to be mandatory, are you just looking at that for the monitoring side, or are you saying that should also be the case for curtailment?
Yeah. I'm going to come back to the use of the word mandatory to start off with. The way that DECA has expressed it in its submission is presumptive. So it should be presumed that there will be the use of technology, and then it's exclusion by exception. And then secondly, DECA's position is that it would serve both a monitoring and consequent upon that potentially a curtailment process. But for instance, I'll give you the example. I mean, don't take this as scientific advice, but this is what the submission says, is that if you do the monitoring up front and you find that the monitoring identifies that there's really a very, very low risk or no risk of certain species utilising the area, then that may impact upon its ongoing use, the extent of its ongoing use, or the need for curtailment.
Yeah. Because the purpose of the monitoring, or one of the purposes, is to better understand the risk to the species. So,
correct. Yeah. And no matter how well resourced a proponent might be, sending people into the field to make human observations is a methodology, but it's not necessarily as efficient. And it reminds me of the Cattle Hill work. Now, let me go to that work. So it's one of the two documents that we filed. The effect of which there were two documents we filed, 340 and 341, I think they are. And what 339 and 340, I'm sorry, and albeit in respect of a different species, what the document 339 what I'll just do is, so this is document 339 at page Roman numeral page 8, and I'll pop it up onto the screen. But it's a theme that's repeated throughout the document. So remember, this was the wedge-tailed eagle at Cattle Hill. So one of the very useful applications of IDF is its ability to continually monitor avifauna activity. Huge amounts of data collected have not only added to the understanding of the eagle's behaviour, developed a detailed record of other species utilising the site and seasonal patterns, such as the timing of migratory species arriving and leaving the site. The volume and quality of information captured by IDF is considered far more comprehensive than what is possible using traditional bird survey methods conducted by human observers. As an example, over a period of 4 months during the development of the wedge-tailed eagle, CNN is the process the plan that they put up there. IDF cameras captured a greater diversity of bird species than the total of all previous human bird surveys dating back to 2009. This included species such as the grey goshawk, thought to be present but not previously detected by human observers over many years of monitoring. So it's that sort of capability of the technology to do more than the human eye, which is persuasive in Deeker's mind as to the presumptive use of its technology to get the baseline right. And what comes from the baseline being right, Member Wilkinson, is you get the response under the BAMP right, and you also get the response under the BAMP right, and you get a much clearer understanding of what species are actually using the site. Because it's no criticism, because there's been a wealth of work done by the proponent in this case, but we know that the language of the evidence and the language of the EES is one of risk and what we know and what we don't know and what we'd like to know. And it just removes some of that attendant doubt.
Mm. Yeah. All right. Thanks for that. Just just one question of clarification, and it's your paragraph 159. You say, as noted in Deeker's, and this is so that we don't misquote Deeker. As noted in Deeker's original submission, Latham snipe, unlike other migratory shorebirds, is likely to move directly across the project area. Actually, just reading that again, I think it's probably answered my question. So that seems to read that Deeker accepts that other migratory shorebirds are unlikely to move across the site.
That's right. Yeah. And that's the point I came back to in relation to the OBP. We're not, it was a point that I think was made in submissions by Mr. Chessel last week about the foraging habitat of the OBP being more confined to the direct coast, etc. And so we're not, trying to overstate it.
Yeah. Okay. And then the final question, it relates to 178. The deferral of investigations on key species is a matter of some concern, and that once a project is approved, the ability for pre-commissioning investigations to influence the operation of the project may be limited. There's a number of ways in which those sort of baseline studies can influence the project, and yes, that work already has, or at least the studies that have been done have already influenced the project in that there's been broader buffers put in. There's a buffer around the southern bent-wing bat from Roost Cape. So there's been some modification of the project. I guess as we get sort of closer to, or really from this point on, it will become increasingly difficult to make changes to the project design, such as moving turbines around or changing the position of turbines. Is that a matter that Deeker is now settled with, that you're not really pushing for major changes to the project design, more around the monitoring, the adaptive management that's now put in place?
Yeah. Well, you can see that consistently the submission applies an approach where these are matters that can be managed by the BAM. And, that might mean that there might be curtailment measures. It might be some other more demonstrative measure that arises from the BAM. But I think it's inherent in that submission that, yes, Deeker's not indicating that there needs to be a chamfer off this end of the project or a this or a that. They're all matters that can be confined within the, I guess, more limited range of control that can be exercised on a project through a document like that.
Yeah. Okay. All right. Thanks for that.
Thank you. Member Kirsch has a question.
Thanks. Mr. Tobin, paragraph 191 of your submission, that's in relation to the independent environmental auditor.
Yes.
And you make reference to Mr. Organ's evidence and support for an IEA role, and that's included in the Day 2 EMF. I'm really, I suppose, just inviting you to explain whether Adika has any broader expectations around what that role might entail, given that the references in the EMF are fairly general.
Yeah.
I suppose that another part of that context for that is I assume Adika would be seeking reasonably detailed monitoring and reporting requirements as part of the BAM. So how would the role of the IEA fit in with that as well?
Yeah, I might get some specific instructions on that and return to you after the break, so I can give you the best answer, if that's okay, Mr. Kirsch.
Yep, thank you.
Thank you. I have a couple of questions, actually, and I'm going to just expand on the question Member Kirsch just asked, to ask if you could also just advise the IAC your expectations of expertise and process for appointment of that role as well, the auditor, if there are any standards associated with that. And then I have a couple of other questions for you. I'm going to revisit with you a question relating to reconciliation native veg as expressed in the handbook.
Yes.
My question relates to the time frame associated with the assessment, the arborist assessment post end of project. So the handbook does say offsets can be reconciled at the end of a project, so that excess credits can be unallocated or banked, etc. So the mitigation measures currently have two time frames associated with that end of project assessment, so 6 months and then the 24 to 30 month following construction. And my question is really whether there is any standard timing for end of project assessment for a project of this type. So happy for you to come back to me on that.
Better.
Thank you. And my final question relates to...
Can I just take a note for a moment so I get your question? Thank you.
My final question relates to the content in DECA's submission relating to the use of new material and the procedural considerations. And at paragraph 22.3, you note that where the material introduces significant changes to baseline assumptions, impact assessments or offset calculations, a structured process for further review or referral may be warranted prior to decision making. And my question is if you could either clarify exactly what's meant by that, and also to be clear as to whether you're saying those matters can be addressed through the mitigation measures in the EMF.
Yeah, that's more notional than specific. So we're not advancing a position where there is some subsequent process that needs to occur before you or the minister could make a decision. I think that's probably the import of your question. Because for a couple of reasons, and I'll give you two different examples. One way that these matters can be addressed is that they are addressed through the EMF and the submissions of plans or the inclusions of leading points in the EMF that permit them to be resolved. The other way that they can be addressed is and if I use the example that we'll be talking about this afternoon, the Section 27 application, that's, of course, we've got a draft application, but we know it's going to be recast. So if there was a matter that there was more information required to inform that, then that would be, that could be augmented through that process. So, for instance, the minister could make a finding that, there needs to be the application need include X, Y, Z before it's advanced for consideration, or further work needs to be done on this before, whatever the case may be. Again, that might be, there are two ways that those sort of decision-making processes could occur in this case. There's nothing that I can submit to you in this matter that says and we would have said it much more clearly if there was, that something needs to occur right now before anything's advanced in terms of decision making.
Thank you. So that's clear. And I might just note the context of that question, as you rightly said, Mr. Tobin, is also that the IAC, as you know, under our terms of reference, is asked to advise on how modifications and measures should be implemented through necessary approvals and consents for the project. So, yeah, having some clarity around the distinction there for our purposes of understanding what DECA is saying, whether they'll be embedded in the EMF or whether there's other tools. Thank you. No further questions from the IAC then. So we'll have a break now for lunch and come back and hear your submissions from Parks Victoria. And I suggest that we break till 12:15, so slightly shorter. Sorry, 2:15. No, let me say again, 2:15. So slightly shorter lunch break, but I'll keep things moving.
Yeah. I mean, I was going to, yeah, actually 2:15 would be good because then I can set up for that.
Thank you.
Yeah, thank you.
Thank you. Welcome back, everyone. Mr. Tobin.
Thank you, Member Kendall. Just to close out those inquiries, the first one concerned paragraph 191 of the DECA submission. It concerned the proposed appointment of an environmental auditor. In terms of fleshing out what DECA say that would look like, firstly, it would be a person approved by the RA. Point 2, it would be at the cost of the proponent. Point 3, they would be, it wouldn't relate to preliminary steps like approval of the BAMF or things like that. That's really in DECA's remit, but it would be, it would relate to the subsequent ecological reports that would be consequent on that and the Brolga plan. In that they'd be reviewed, and then the last point is that second to last point is that the auditor's findings would be public, and then lastly that they'd be provided to all the parties, that is to the proponent, to the RA, and presumably to my client DECA, when they issue their assessments. Now, I have to have a think about how much of that needs to be reflected in an EMF, but that's the shape of what DECA would look for, and they've done similar things on large-scale rail projects and things that they seem to be that's an adapted version of what seems to be their common approach. The second matter related to the document, which we didn't write down, document 285, was it? Yep, document 285, which was a document submitted by submitter 282, and what that is a internal memo released under Freedom of Information, presumably, which explained at the time proposed changes to Brolga mitigation standards. And the question, as I took it down, was whether the rationale in that report could be used to understand the rationale sitting behind the more recent guidelines approved under the handbook. The answer, as I'm instructed, is that no, that wouldn't be a safe approach to adopt it. No doubt the rationale within document 285 has helped to inform the broader knowledge and what's advanced through the process, but the handbook was itself subject to its own work, was then subject to multiple rounds of public consultation. And so, as I'm instructed, it wouldn't be safe to assume a direct linear relationship between document 285 and the handbook. Lastly, there was a question about the timeframe stipulated under the handbook, the Assessor's Handbook. The Assessor's Handbook sets out potential times. It's a guideline. There is no specific timeframe that DECA would nominate of those timeframes or in relation to this project, noting that the election to reassess under the handbook is an assessment that would be made at the election of the proponent. And so we don't really have much more to add to assist you on that point. Sorry, the last point in relation to that was that some projects where there is reconciliation, large state projects, it's a long time between the initial calculation and the ultimate reconciliation. So it wouldn't be, if that was the approach taken, something that would have a tight turnaround. It would have a generous turnaround time. Yep.
And other than general advice in relation to that, with some projects do that.
Yeah.
Is that just
I don't have
comment
anything
only?
else
Yeah, thank you.
specific. I can try and hunt it down if it would be of assistance.
No, thank you. I'm happy to leave it there. Thank you.
Okay. Well, I think that.
Oh, yes. Sorry, Member Kirsch has a question.
It's not for you, Mr. Tobin, but it's on the basis of the information you just shared. It's just a matter for Mr. Cheswell and the proponent, and in relation to the role of the IEA for the BAMP. And we've heard Deeca's position in relation to that. So clearly, at some point, a response would be useful for us. But can I just ask a broader question, and again, take this on notice? When we go through the EMF and see references to independent environmental auditors, it's not always clear whether they're, in fact, that's the same person, or who appoints them, or under what basis they're appointed, whether they're auditors under the EP Act or... I just think at some point it would be useful to have some clarity and review around that issue and that role in different manifestations.
It's a matter that I'm aware has arisen in the context of processes like this in respect of large infrastructure projects, and in those contexts, it's contemplated generally that role be shared amongst a number of people with different particular specifications and expertise. In a project like this, I suspect that's not the case, but I understand the question, and we'll come back with some further clarification about how it is that person is to be appointed, the particular role that they will perform, including in respect of the BAMP. And we note that under the existing framework, BD 12 does already contemplate that auditor reviewing the BAMP, but we can flesh that out in a little more detail. Just so I'm clear, is the question one that concerns specifically the role of the auditor in respect of the BAMP, or is it a broader?
So that's the first question,
Yep.
and it's specifically in relation to the discussion that we had with Mr. Tobin. But the second question, I suppose, is a more broader question, and it's about reconciliation of the terminology in the EMF, where it's not always clear who the IEA is and who would appoint the IEA and what that person's specific role is.
Yeah,
no, I think there's probably some, as you've alluded to, there's probably some straightforward answers to that. It's just not always clear.
Yeah, no, that's fair.
It's expressed.
That's clear. Thank you.
Great. Thank you, Mr. Tobin. I'll hand back to you to take us through Parks Victoria's submission.
Thank you. Save for that first comment that I made this morning about the more or the narrow expertise of Deeca and Parks comparatively, and I made the point that Deeca has perhaps a much more narrow lens over the project, energy and ecology. PV has a narrow focus over the project in terms of the land that is affected. But in other ways, it's a broader lens than that of Deeca, because Parks Victoria has an interest in the planning scheme amendment. And of course, that's a very broad, a broad assessment, taking in all those aspects of community benefit, whereas Deeca's lens on the PSA is more about the implementation of the EMF. So I put that just to really qualify what I said this morning. In the submission which you've got, which is document 394, at paragraph 2, we make the point that Parks Victoria was a TRG member. It has two broad interests in the project. It has an interest in respect of consent under Section 27 of the National Parks Act. And to that extent, we refer at paragraph 4 to the consent, the draft consent application under Appendix Z. I will say, by way of introduction to that consent, there's actually, in terms of the the broad brushstrokes. Having listened to the proponent's submission on Section 27 as to the legal mechanism, and having read the proponent's submission, there's not much light between us on that question. Perhaps we take a slightly broader view of which objectives are relevant. I'm not sure, and I'll come to that difference in the course of the submission. But I think it's more a question of, I guess, what comes from that assessment is the difference between the two parties, and we'll be asking you to consider a slightly different way of looking at some aspects of the test, the common test between the parties in forming your own view about those matters. And secondly, at paragraph 5, we talk about really the impacts on what we call the Parks estate. That is the impacts of the planning scheme amendment on the Great Southwest Walk, the Swan Lake campground, and the Lake Mombiong campground. We make the point that Parks Victoria hasn't tried to assess all matters. It's not trying to be all things to all people in respect of this matter. And accordingly, this assessment of the matters that are relevant to Parks is something that you would fit into your broader assessment of community benefit. So Parks Victoria is a statutory authority established under the Parks Victoria Act. It's responsible for the management of public land reserved under the National Parks Act. That includes the Kaboboni National Park, the Lower Glenelg National Park, the Discovery Bay Coastal Park. And in performing its functions, it must have regard to its objects. And it's worth spending a bit of time on those objects because they're quite narrowly focused to protect, conserve and enhance Parks Victoria's managed land, including its natural and cultural values for the benefit of the environment and current and future generations. Recognise and support traditional owner knowledge and interests in Park Victoria managed land. Provide and encourage community enjoyment of its land. Improve community knowledge and appreciation of its land. Contribute to the well-being of the community. And contribute to the achievement of state and regional land management outcomes so far as it is consistent with the effective protection of its land. Now, the Parks Victoria estate is a diverse estate, 4 million hectares, 3,000 land and marine parks and reserves, 18% of Victoria's landmass, which is substantial, and 70% of its coastline. As relevant to this matter, it's the designated land managers for several parks and reserves within the project area, including Kaboboni National Park, which was formerly reserved under the National Park Act only in 2008. Why is 2008, or why is the identification of that number particularly relevant? Of course, when we're talking about the existence of the road, which the proponent has said, and we agree, Boiler Swamp Road has been there for a long period of time, even before the park was identified as a national park. Likewise, other examples that you might see going through national parks, and I'm thinking down near on the Great Ocean Road when you see those big electricity lines through national parks, frequently they predate the designation as a national park, and so some care needs to be taken about how one characterises what infrastructure is in national parks and whether when they're looking at the Section 27 consent that we'll come to. Parks Victoria. Section 38(1) of the PV Act requires the preparation of a land management strategy. So this is, first of all, under the PV Act that sets out the general long-term directions and strategies and priorities for the protection, management and use of land by Parks Victoria. And that is the Parks Victoria Land Management Strategy 2022 that we have linked in the submission. I realise that we probably haven't uploaded that as a separate document. I don't know if the committee would like me to do that following this submission, but we've extracted the part that we think is most relevant. And in particular, over the page, at page 3 of 29, we set out the planning framework, and you'll see that these high-level strategies, this fits in the middle in the land management strategy, and you'll see that that then slides into park management plans at a landscape and park scale underneath that, which of course is the plan that we've spent a bit of time with already in the context of this proceeding. Now, the guiding principles of the land management strategy include to protect natural and cultural values. So ecological and cultural integrity of parks will be strengthened by being protected and managed at a landscape scale, improve the ecosystem. The next heading is maintain and strengthen the park's estate, that all parks will be managed according to their specified purpose and function to protect in environmental, cultural and social values. All actions will enhance parks, reflect best practice, embrace universal design, including access, equity, diversity, quality and sustainability. The land management strategy, albeit briefly, does acknowledge that there is infrastructure within some of the Parks Victoria estate, and that extract there is from page 38 of the land management strategy, where it's acknowledged that licensed critical infrastructure such as power lines and water pipes occurs in parks. Park planning considers this infrastructure, its security, the safety of visitors in collaboration with the agencies that own and operate it. And that really deals with, I don't intend to take you to the higher level strategy at this point in time in any detail. We then come to the National Parks Act, and Section 4 of the National Parks Act relevantly include the preservation and protection of the natural environment, including wilderness areas, protection and preservation of Indigenous flora and fauna, and features of scenic, archaeological, ecological, geological, historic or other scientific interest, study of relevant matters, responsible management, and to make provision in accordance with the foregoing for the use by the public. This submission addresses the application of the National Park and the PV Act in the context of the proposed transmission line and the statutory and practical implication that arise from Parks Victoria's role as a land manager of the parks affected by the project. We describe at paragraph 17 and 18 the way in which the National Parks Act identifies by schedule the various types of parks under its control. And so Schedule 2 identifies the Kabobani National Park according to its reference plan in the Central Plan Office. And the Discovery Bay Coastal Park is what's described under the Act as other parks, as opposed from national parks, and that's described in the way below there. Or at paragraph 19, the function of Parks Victoria in respect of national parks, Parks Victoria must ensure that each national park and state park is controlled and managed in accordance with the objects of this Act in a manner that will preserve and protect the park in its natural condition for the use, enjoyment and education of the public, that will preserve and protect Indigenous flora and fauna in the park, that will exterminate or control exotic fauna in the park, eradicate exotic flora in the park, and preserve and protect wilderness areas there after that. Then we just go down to C below that. Promote and encourage the use of national parks and state parks by the public. B I should have gone to, which is protection from injury by fire. C, which is promote and protect the use and enjoyment, promote and encourage the use and enjoyment of the parks. And then D is to prepare a plan of management in respect of each national park, state park, which may be included as part of a land management plan within the meaning of Division 4 of Part 3 of the Parks Victoria Act. Section 18 describes the functions of Parks Victoria in respect of those other parks, of which the Discovery Bay Coastal Park is one. It is to ensure that each park referred to in subsection 1 is managed to preserve, protect and re-establish flora and fauna, preserve and protect features, enable the park to be used for the enjoyment, observation and study of the countryside and its pursuits. Again, promote and encourage the use of the parks by the public and prepare a management plan. So we then come to the Southwest Management Plan, the NGNM plan, which of course is the approved plan, management plan for a network of parks and reserves in Southwest Victoria, including Kabobony National Park, the Lower Glenelg National Park and Discovery Bay Coastal Park. It was prepared by PV in partnership with the Gudjunmara traditional owners and endorsed by the then Department of Environment and Primary Industries. It applies to more than 130 parks and reserves and sets strategic direction for protection of cultural landscapes, biodiversity and visitor values. It is a document approved pursuant to the National Parks Act and is a key instrument in Park Victoria's practical management of the relevant areas. To the extent that the NP Act creates, or National Parks Act creates discretions, pertinently a discretion under Section 27, the PV Act requires considerations of its objects in that function, and the NGNM plan plays an operational role in guiding Park Victoria's management of the parks within its scope and in informing decisions about permitted activities, use and development and conservation priorities. Now, the parks covered by the plan are primarily managed for conservation purposes. It includes, the plan itself includes its own zoning framework. That's not a planning zoning framework, but it's a use zoning framework that identifies areas of heightened cultural landscape sensitivity. I'll just open the plan. I just haven't got the document number here. So what I'll do is do this. Okay.
Mr. Tobin, I know it's been referred to previously, but in the submission, is it a table document? I'm not.
It is a table document.
Yeah.
I can't see the number. I'll take you to the plan. It was tabled, I think, on day one. Mr. Chessel, I think, might have taken the committee to it, but I'll double check that and come back to you over the course of the afternoon.
Thank you. I think I've seen it as a link in a document similar to how you have it now.
Yeah.
Which is, as a public document, is acceptable.
It is indeed. So the plan itself, the first reference in the plan that we're going to take you to is page 25. And we make reference to these zones that are identified within what they call the planning zone area, but there's actually a broader range of different zones that are not, in fact, planning zones in the sense that we would know them.
To enlarge that on the screen.
Oh, sure.
Possible, thanks.
Now, at page 34 of the plan, now, sorry, I'll just go back to the written submission for a moment. So at our paragraph 24, Parks Victoria's position is that I guess the IAC's assessment of environmental impact should, of course, take account of the plan and indeed take account of the plan's stated management objectives, which is, of course, the purpose of those zoning controls under the plan itself. And relevant to the proposal, there is a specific reference to the Kabobani National Park, and the species goal as relevant to this proposal includes the following: the species richness and abundance and breeding opportunities for hollow-dependent fauna, including woodland birds, the brush-tailed phascogale, but relevant to here, the yellow-bellied glider, is maintained and improved, with focus areas being the Kabobani National Park and also the Kabobani Forest Park, but relevant to Parks Vic, the National Park. It's also, there's direct commentary on the Great Southwest Walk, and in a number of places in the plan, but this perhaps is the most appropriate summary, that trails are one of the essential means of enabling visitors to experience the parks at close quarters and to gain access to key features of the park. The area offers various things. There's over 40 walking tracks, the most significant being the Great Southwest Walk, includes dedicated walking sections and sections along beaches and vehicle tracks. It's included in Victoria's Trail Strategy, 2014 to 2024. It's a state significant trail with Tourism Victoria, and there's a key challenge is the ongoing maintenance of the trail. And then there's also guidance on the Great Southwest Walk at page 79 of the plan. So in terms of Parks Vic, it's here as the statutory land manager of the affected park estates, and as the consent authority under section 27 of the Act. And so it's the statutory decision it must make and the potential impacts on the park estate itself. land obviously reserved under the NP Act must be managed consistently with the purposes of the reservation and any approved management plan. At paragraph 30, we say that the proposed infrastructure corridor traverses land under the National Parks Act and subject to the NGNM plan, and is in an area under the plan zoned for conservation and identified as having high ecological, cultural and landscape value. So Parks Victoria therefore has an obligation to assess how any proposed use of that land, including temporary construction and permanent or semi-permanent infrastructure, would affect park values. Now, if I just pause there, the way the Section 27 consent application has been presented is that, it has been more or less to say, well, it's on a road. The road is a long disturbed road. It's compared to the whole in terms of the park, there is a relatively small footprint of the project, and there's a submission to say that you shouldn't assume that all that vegetation is lost, and so therefore it can't be what the Act comes to and the test that we come to. May fit the test of may substantially affect. In relation to those characterisations, Parks Victoria says, while it's true that the project is along a road, the project is on its own terms assessed as having an impact on the national park adjacent to it. And the nature of that sort of presumptive vegetation loss is an impact for the purpose of the native vegetation guidelines, and is an impact therefore for the national park. And so it seems to us that the way in which the submissions were presented perhaps sought to diminish or characterise the impact as being very small. But what we'll seek to do through the course of these submissions is to demonstrate that the impact of the proposal on the national park is not insignificant, and there is something for the committee to think about in it determining whether or not the consent application is appropriate, and whether the minister might have grounds to form a view that the proposal may substantially affect the national park. Now, in terms of, if we move on briefly to the planning scheme amendment, of course the PSA will be inserted into the Glenelg planning scheme. The incorporated document will implement the EMF. The EMF will regulate the use of the project land, but it will relate directly to also the use of land within the national park, and it will implement the project land in a way that will affect the park's estate in other ways, such as Lake Mombiong. We make the point in paragraph 35 is that the EMF is intended to operate as a central mechanism for managing the environmental effects across the project area, and supports the use of structured frameworks to guide mitigation and risk. The EES process has already led the proponent to make a series of changes to the EMF to address submissions and evidence, and further matters are presently under consideration. For example, the unresolved suggestion of a second jetty and other visual amenity interventions at Lake Mombiong. And we say that the EMF is a key document for Parks Victoria in the way that it can affect its management of the park, or at least its experience of the park or the experience it provides. So if we turn to section 27, now, as we set out, as we stated above, Parks Victoria is the designated land manager, and it's responsible for ensuring that land use and development within the park is consistent with the national park and the broader land, including the protection of environmental, cultural and recreation values. In the second half of paragraph 38, as exhibited with the EES, this would result in the loss of 1.9 hectares of native vegetation. Assumed loss, but 1.9 hectares, which includes 278 trees from the national park, 145 classified as large trees under the applicable ecological vegetation class. And it's not known how many of those trees are hollow bearing. You might remember there was an exchange with the witnesses about whether surveys had been undertaken for hollow bearing trees, and to date they haven't. And I understand that's being picked up in the or it has been picked up in the EMF. Based on the EES documents, threatened flora will be impacted. That's the 37 western peppermints within the park, and that's vulnerable under the FFG Act. The proposed vegetation removal will have an impact on threatened species, including the Gangang cockatoo, the yellow-bellied glider, and the long-nosed potteroo, all of which are protected now under the EPBC Act. Now, it's right to say that the evidence from the ecologists, and in particular this was Mr. Gibson's area, was that his evidence was in respect of the yellow-bellied glider, that to the extent that it was disturbed, it would relocate to deeper within the national park. But that's not to say that that's not an impact that is relevant to the assessment of the task at hand. We make the point in paragraph 41 that the assessment that you undertake should, just as we've submitted on behalf of DECA, should take account of what the EES says and not the possible reduction in the removal of, or the deemed removal of native vegetation pursuant to the processes that the EMF and Mr. Galbraith's evidence identifies. This is because under the construction of section 27, one of the considerations is that the minister needs to think about impacts that may arise or that may substantially affect. Now, the authorisation for a public authority to have a transmission infrastructure within the Kabobani National Park is the consent under section 27. And section 27 provides that subject to this act, a public authority may, where it's obtained the consent of Parks Victoria, perform functions and exercise powers in the park. Now, that consent cannot be given where the minister considers that the performance of functions or exercise of powers may substantially affect a park. And that's subject to a further caveat unless the Governor and Council has determined that that consent must be given. And we'll give you an example in the course of this submission of one case where there was substantial effect in the Minister's eyes, and the Governor and Council directed that permission issue. The consent of Parks Victoria, it may be subject to conditions, and I think that's all that we need to take you through that point, and that's summarised in our paragraph 44. Now, section 3.2 of the Act refers to a public authority, and Mr. Wright took you to this in the course of submissions. At paragraph 46, we say, to date, Parks Victoria has not needed to form a concluded view about whether the proponent is a public authority in the context of the draft application. We don't think it's material to your considerations. Ultimately, at the time when an application is made, it'll need to be made by someone with that title. So we don't think it's material to you, and we're certainly not going to argue that the proponent or whoever ultimately builds and owns the transmission line will not be a public authority. I don't think that's a useful debate or even a relevant debate to have. We then come to, at 47, this limitation where a proposal may substantially affect a park, and the, I guess, overriding provision of the Governor and Council. At 48, the consent application for consideration by Parks Victoria is not framed by any explicit consideration or guidelines. So if I stop there, unlike the Planning and Environment Act or the planning scheme where you get neat decision guidelines or acts where they say you've got to consider this or that, there is nothing outside of the broad objective that Parks Victoria must, in exercising its function, have regard to the objects of the PV Act and the objects most pertinently of the National Parks Act. It's therefore a role of Parks Victoria to exercise its view on whether any consent application having regard to whether to grant any consent application having regard to the objects of the National Parks Act and the objects in respect of a national park, given that's what Kobobini is, under Section 17 of the Act. That is, whether it's going to be in furtherance of the objectives, would be neutral to the objectives, or would operate against the realisation of those objectives. And that's not a test stated in law. That's just really, that's going to be the process of reviewing an application and its consistency with those objectives. We make the point at 49 that that is a narrow test, much narrower than the balancing exercise that you find under the Planning and Environment Act. The proponent has indicated that the draft Section 27 application within Appendix Z is to be recast. It's not before the committee, but no doubt that will happen in due course, in due time, due course rather. But at paragraph 50, we say that in Parks Victoria's view, this is appropriate. The present formation of the application is long, and it addresses matters that are plainly relevant, such as ecological and management issues, but it also addresses material that, if relevant at all, is remotely relevant and more akin to a balancing exercise. And we just take a few snippets from the Section 27 consent application, which in Park Victoria respectful submission at their highest framing, but aren't relevant to the actual decision, we would say. Likewise, the consent application places some stead in Technical Appendix A, the transmission line options assessment. The options assessment is a tool that has been used to inform a preferred route for the transmission line by the proponent. It's considered separately in this submission. It may, it'll be clear that Parks Victoria questions some elements of how the options assessment was undertaken through the questions that we've asked, but it's not really doesn't bear on the Section 27 consent application, because ultimately Parks Victoria, if a person asks either in the with an options assessment or without an options assessment for consent to do something in the park, Parks Victoria has to consider that application. And how does it construe that application? It construes that application, or how does it assess that application? It assesses the application against the objects of the Act. Now, at 52, we just make the point that the options assessment that canvasses a route through the park or external, whether a route through the park or external to the park should be adopted, on a range of criteria, including private property devaluation and community sentiment and other things, all relevant things for an options assessment, is not something that's going to operate on the Section 27 application. Perhaps most pertinently, or to the extent that it is relevant, the alternative options don't require vegetation removal, but it still falls to Parks Victoria to assess what is proposed. At 54, we make the point that this committee's and the Minister's assessment will be considered in respect when Parks Victoria comes to evaluate the Section 27 application. And accordingly, there's great value to the committee's advice, which the March submission from Parks Victoria explicitly seeks, in respect of the question of how the transmission line performs against the objects of the Act. There is also merit in Parks Victoria's submission in the IAC considering, in the circumstances, the phrase may substantially affect under Section 27(2) of the National Parks Act. Somewhat like DECA, at paragraph 56, the observation is made that Parks Victoria doesn't express a concluded view one way or the other on whether the consent application should be granted or whether it may substantially affect, whether the substantially affect threshold is met in the instance of the draft consent application. That's not a matter of, I guess that's Parks Victoria's position on the basis that it's, I guess it needs to consider the IAC's recommendations as a relevant matter pursuant to the operation of the Environmental Effects Act, or it needs to consider the Minister's assessment at least. At paragraph 58, we set out in a table form the objects of the National Parks Act and the Section 17 control and management obligations. Now, it's important in setting these out to highlight that while the submissions you received were correct in saying that the park contemplates that there will be some infrastructure within parks, it contemplates that public authorities may seek consent. There's nothing in those objects that goes to further that. It's not written into the purposes, it's not written into the objects, it's not something that is otherwise specifically contemplated. So again, that goes to the fact that there isn't a balancing exercise on foot here between infrastructure and other elements. It's a question of whether whether the application is consistent with, or really having regard to them, is not going to offend in a material way these obligations, or these objects rather. Now, we think that table operates as a useful way of setting out some of the objects of the Act. I think the difference between the submissions, submissions made on behalf of Parks Victoria and those made on behalf of the proponent may only be that I think the proponent focused on the objects of the Act, whereas Parks Victoria has focused on both the objects of the Act and the objects of, or the control and management obligations of Parks Victoria in respect of national parks. So If we turn to the meaning of may substantially affect, we've set out some principles in relation to statutory interpretation. Again, we don't think any of this is particularly controversial. You could quote different cases, you could look at it in different ways, but there isn't judicial consideration of this phrase, and the phrase is not defined anywhere in the Act. And so what we say at 64 is that the principles of statutory interpretation are useful in construing Section 27 of the Act, which establishes a statutory control framework governing when a public authority may perform functions or exercise powers in relation to a reserved parkland. And we say as a provision embedded in what is protective legislation, it must be interpreted purposively and in a manner that gives effect to the text, context and statutory objective, which is the preservation and responsible management of the environment and cultural values on the land. Now, we then, at our paragraph 67, set out some definitions just from the dictionary. Firstly, there's may, and may substantially affect. Well, it's a possible impact. And so that's the basis upon which it's submitted to you, that the possible impact you are assessing is the impact of the impact described in the EES, because that is on the proponent submissions the worst case outcome, but that is a possible outcome in the event that the investigations of routes doesn't change the assessment of vegetation loss. Now, substantial, there's a range of definitions, but what we say about substantial is that it is definition 7 relating to the substance, the matter or material of a thing, relating to the essence of a thing, essential, material or important. It doesn't, of course, mean something that is predominant. And we say that it can't mean that it's got to be an enormous impact to substantially affect a national park, because the reality is that, having regard to the purposes of the Act and what national parks are, there's never going to be an impact that could be contemplated that will be truly significant in area or truly significant in outcome that wouldn't be a substantial impact. Parks Victoria reads this as being a more careful and nuanced approach to what a substantial impact. And so at 68.1 we say may is a threshold of reasonable possibility, not certainty. 68.2, substantial requires that the effects be material or significant, extent or consequence, rather than minor or trivial. And then effect means encompasses a broad range of effect on the condition or values of the park. So at 70, in conclusion on this issue, Parks Victoria submits that the phrase captures a proposed activity that gives rise to a real and discernible possibility of materially altering or diminishing the environmental, cultural, recreational or operational values of a park. It's not limited to large-scale infrastructure. It might be met by smaller or temporary activities. And it doesn't require definitive proof of harm. Now, in this case, what are the potential impacts? And they're listed at paragraph 72, that it might be the clearance or fragmentation of threatened species habitat, the removal or disturbance of native vegetation or culturally significant features, disruption to ecological processes, impacts on character, visitor experience, etc. They're the type of things that could trigger the threshold. And then we say the impacts in this application are set out at paragraph 75, potential impacts. So deemed loss of vegetation, the deemed loss of hollow-bearing trees, impacts on threatened species, impacts to threatened species habitat, should the trees fail, the potential loss of hollows, temporary impacts on access for the Great Southwest Walk, and increased fire risk, though DECA have concluded that that is manageable, and Aboriginal cultural heritage, albeit that there is some weight to the submission that the area is already disturbed on the road itself. Parks Victoria accepts that the NP Act contemplates that a public authority may use the park for infrastructure purposes or even other purposes, at least in theory, and that the objects of the Act cannot be elevated to being prohibitions, such that any impact on national park ecological values is unacceptable. That wouldn't make sense. A purposive approach to interpretation suggests that the impact is whether the issue is whether the impacts compromise in some material way those objects. Now, I'm instructed that Parks Victoria would have up to 2 or 3 of these applications in a given year. They have, at 78, we say they have appropriately historically approached the exercise of discretion under Section 27 of the Act cautiously. It's consistent with the fact the objects of the Act and the obligations of Parks Victoria in respect of national parks are protective in their nature. It's tried to say that a discretion to grant approval exists, technically for anything advanced by a public authority, and that in creating the direction, the potential was contemplated by the Parliament. That's all true. That's sort of what the proponent advances. However, the structure of the legislation is unusual. Parks Victoria is subject to the oversight of the Minister. So Parks Victoria don't hold this discretion or can be deprived of the discretion given to them in certain circumstances by the Minister if they form the relevant state of mind. And the restrictive nature has meant that there have been relatively few consents sought or granted. There are also a number of linear projects in parks, but many are historic, Boiler Swamp Road itself being an example of this. Now, a recent example of a consent application that exceeded the substantial impact threshold is the Colac water pipeline upgrade. That concerned a project for a water pipeline located in the Great Otway National Park, Otway Forest Park, the Bangarook Road Reserve and private property. The application to Parks Victoria sought the removal of 7.3 hectares of vegetation from the Great Otway National Park. And the Great Otway National Park is a substantial park. It's about 6 times the size of the Kabobani National Park. In that instance, and I'll take you to a couple of documents, or I'll just point you to parts of the documents that we've filed. The Minister determined that the park may be substantially affected by the removal. The project was approved and indeed is on foot as we speak, but was approved by operation of Section 27.2 at the direction of the Governor and Council. We make the point that no 2 projects are identical, so we're not holding this table out as a rationing provision or a ratio that is to be adopted. But the vegetation removal in the Great Otway National Park, which is a park significantly larger, some 5 or 6 times the size of the Kabobani, was 7.3 hectares. In that case, it was both direct impacts, so there were 3.5 hectares of direct removal impacts and 3.8 hectares of assumed loss. That is loss like that which you've got on the in the Kabobani National Park. In the case of the Barwon Water Pipeline, vegetation, including hollow-bearing trees, were the subject of impact and removal, which was habitat for the Gangkang cockatoo, the yellow-bellied glider, and the long-nosed potteroo. The project was determined to be a controlled action, so there's a difference. At the time that project was advanced to the Federal Minister, there had been a change in certain EPB listings. You might recall in this project, the timing of the referral in this project means that certain listings after the referral for the project here mean that they are not taken to be, or those newer listings aren't accounted for. And the loss of hollow-bearing trees was noted as a key threatening process under the Flora and Fauna Guarantee Act. Now, there's a couple of documents that the Parks Victoria has put in, and we're only putting them, we're not going to take you to, again, I'm very mindful to say that these sort of documents are sometimes not very useful for different projects because they describe different projects, different circumstances and so forth. So we're certainly not holding it out to be anything more than an example of another project. So what I've got here is the document 403
You're going to share, are you, Mr. Tobin?
sorry, I've just I was just resizing it, apologies. Just one page. I want to take you to a page which outlines a view of the project. That's it. So this is page 9 of document 403. You can see that the project went through the park. It actually adopted a route that was along but augmented an existing pipeline track through the park as part of the renewal, and there was a range of direct loss and deemed loss associated with that project through the national park. Now, this is part not of the Section 27 application. This is part of the EPBC referral documentation taken from the publicly accessible EPBC public portal. That report goes on to describe the various impacts. I think much of the report is not directly relevant because, as I say, that was a proposal that was a controlled action. We've filed the approval that went with that particular project, so that you've got you can see the federal approval for the significant impact to be taken, and it also identifies in document 40 it also identifies in document 403 the various conditions of that federal approval, which we don't think much turns on. We just wanted to make the point that it was actually deemed to be a controlled action as opposed from the project. Now,
Madam Chair, not to, and apologies for interrupting, but if Mr. Tobin was about to move on from that particular example topic, I have a question of clarification that we would like to make. We'll request, please.
Are you about to move on from that topic?
I was going to finish the topic, but now's as good a time as any.
Only because the map was just shared on screen through that document. I have some familiarity, albeit vague, with that location. And I've had the opportunity to identify one other document that provides a bit more detail about the alignment of that proposed pipeline track. I have a vague understanding that the location, the particular pipeline track, if not in totality in parts, is quite different in character from Boiler Swamp Road in material ways. And I just query whether Parks Victoria is able to provide any additional information to the benefit of the committee about the particular attributes and characteristics of the pipeline track, really as the point of comparison. We've heard what Mr. Tobin said really about the qualifications he's given about the relevance of that as an example. But if there are material differences between the roadways.
Are you suggesting or asking if Parks Victoria have considered a specific document?
No, if the Parks Victoria has more information about the characteristics of the track, the road that's under which the current pipeline and proposed pipeline would be going. It just, if there are material differences, it would be a relevant factor to the weight that one could put on that example.
I'm happy for you to respond, Mr. Tobin.
What I'll do is I'll get some instructions from the.
Question,
I mean, it might just be a matter that the proponent wishes to address in closing.
Yes,
well, we would, except if Parks Victoria has the information, we can't get the information. So without going out there and taking photos, but if the information is available, then it's a matter that the ISC may.
Oh, okay. So sorry, I didn't understand it to be a request for information.
Yes.
I thought it was a prompt. For some other reason. I now understand the question. Yeah.
Thank you. I'll let you come back to us on that. Thank you.
Okay.
So we will break when you finish this topic, Mr. Tobin.
Sure.
Just to note that.
So all we say at paragraph 83 is we accept that it's difficult for any project to make good a proposition that it's consistent with the, or at least is in furtherance of the objects of the National Parks Act, because it is something that doesn't go to the core reason why we have national parks. So it's difficult. Any project is going to have difficulty in saying, well, here's a good thing for the park. Because we're putting this infrastructure into the park. So we're not holding it out that you've got to have a positive impact, just as this, which was approved by the Governor and Council, had an impact on the park, just as the transmission line will have an impact on the park. An impact on the park is acceptable. It's a question of whether whether the is acceptable in principle. It's a question of whether the impact in question is acceptable in the circumstances. Now, we observe in 83, we say that the project seeks to utilise a road is one way in which the impact has been minimised, but it has not eliminated impacts on the national park. And we note the fact that in part of the Barwon water pipeline upgrade, it appropriately included the same measure. So all we lead to conclude on that view in respect of that is you have the proponent's submissions in respect of the national park and the fact that it says that there is a very small impact on the park. I say by précis, really, not to be unfair to the submissions of the proponent. It says that the impact is not a substantial impact. Parks Victoria say that it is these are always difficult questions, and that it would be open to take a different view in the circumstances. And perhaps I've just got a message from the client, I think, in response to Mr. Wright's question. So perhaps that's a good place to stop there.
Sure.
And we'll come back after the break.
Thank you. Yes, I'm happy to stop. I do just have a question of clarification that I'll put to you before we break. I'll just check if there are any other questions. Right? You do? No, you're right. Thank you. So my question relates to the table that's at your paragraph 58, and it's really just to make sure that I was clear on what you were saying. And I heard you refer to the proponent having done an assessment against the objects of the National Parks Act, and that your submission details also a response against the Section 17 obligations. And I was just wanting to be clear that in referring to the proponent's submissions, specifically which part of their submissions that you were talking
So
about.
document 386 is the proponent's submission, and it follows a similar course.
Oh, thank you. So just the closing submissions. No, that's fine. Apologies. I just wanted to make sure I wasn't missing it in any other documents. So that's clear. Thank you.
And the only distinction we draw between the analysis, we don't take issue with the setting out of the legal framework. The only difference between the two is that we say in the context of a national park, you also have regard to the management obligations under Section 17. They're not referred to, I don't believe, in the proponent's submission. That they largely overlap, perhaps with the exception of fire, which is part of the management obligations under Section 17. I don't know whether that's an issue having regard to that, but it may be, but I don't think it materially changes the analysis either way.
Thank you. We'll break now for 15 minutes, so come back at 3:45. Thank you. Thank you. Great. We'll come straight to you, Mr. Tobin.
Thank you, Member Kendall. We'll get some. I understand the import of the question from Mr. Wright is to get to the bottom of what the pipe track is in terms of the Barwon water application. We'll get some photographs and circulate them to the proponent in due course and file them from my client. So I haven't got them to hand, but I'll get those and provide those to you.
Thank you.
The second thing to note is that just as way as background context to that application from Barwon Water that we've got there, that was an application that received a planning permit for the removal of native vegetation through the council with DECA support. Also, DECA supported the removal of the native vegetation. So we only make that point to say that they're different tests, different approaches, and each discretion has its own.
Yes, thank you. We understand the context in which you've presented that information. So.
Yes, that's right.
Yeah.
Now, the next issue there's a brief discussion within the submission, which goes to the which commences at paragraph 86 and concerns the options assessment. Parks Victoria spent a little bit of time in relation to the options assessment, questioning witnesses. As it transpired, many of the witnesses who appeared before you had not had direct interface with the options assessment. Some had, some hadn't, or they'd looked at it in a material way, or others, such as Mr. Van Oster, had poor recollection of the extent to which why specific criteria were adopted. Look, insofar as Parks Victoria has sought to explore that issue, we have just set out that the options assessment is something that is a creature arising from the scoping directions, and that's set out at our paragraph 87. The scoping directions include a requirement that the EES document the proponent's design and development process leading to the project design, consideration of feasible alternatives, and an explanation of how specific alternatives were shortlisted for evaluation. And the EES should document the likely environmental effects of alternatives. And we do note at the bottom of the second paragraph there that the depth of investigation of alternatives should be proportionate to their potential to minimise potentially significant adverse effects, as well as meet project objectives. Now, we make the point at paragraph 89 that the options assessment really is a bit of a finely balanced document. By this, it's meant that the criteria selected to evaluate particular issues guide or materially change the outcome. So the options assessment acknowledged routes through the national park performed worse on criteria relevant to Parks Victoria. So you'll see that quote there from the options assessment at page 6 of 97, in that they had an increased impact on the national parks, obviously. But equally, the options assessment is clear that what's driven the selected route and the route before you to evaluate is were other matters at play. And so there's a quote there from the report to say that the proponent worked closely with potential host landholders in the community to understand community sentiment. 2A, that's the external route with an above ground transmission line, was strongly opposed by the community that proceeding with it would generate a negative sentiment and reduce the level of trust the community have with the overall decision-making process and in the proponent. Parks Victoria emphasises that the reserve status of the Kabobony National Parks has certain statutory implications, and the infrastructure must respond to the National Parks Act. The options assessment considers a range of relevant and irrelevant matters to that assessment. It does so at a very high and preliminary level. Of course, you can't have a full EES for every design option. To that extent, the options assessment is only useful where its criteria promote an appropriate assessment, and the assessment criteria are, from Park Victoria's limited view, unlikely to promote a useful understanding of the issues. It doesn't explain how obligations of the National Park Act, including the protection of enhancement of works, were factored into what's a multi-criteria analysis or overall route selection. I guess what we just say about this is you've ultimately got the assessment that you've got to make. The options assessment's not a helpful tool. We say in making it. I think the proponent submissions were that it's irrelevant. We don't disagree. The options assessment is there for a different purpose and really doesn't operate on your decision-making framework in respect of that consent position. Now, we then turn to biodiversity impacts, and the substance of the biodiversity submission on behalf of Parks Victoria is really that the project, including the transmission line, intersects a range of vegetation communities. Biodiversity values in these areas include mapped native vegetation, scattered trees, ground layer habitat, and known or potential habitat for species. And these factors contribute to broader ecological processes such as habitat connectivity, species movement, and landscape resilience. We note that it's not just direct removal. In fact, in this case, the principal effect is indirect removal or presumed removal. The net substance of this is that, a bit like DECA, Parks Victoria asks that your assessment of impacts is a precautionary or worst case approach that doesn't take account of Mr. Galbraith's assessment or opinion of the likelihood of reducing the number of deemed losses through the transmission line, simply because they're not matters that are yet evidenced, or to the extent that they are evidenced, they're evidenced only by opinion rather than empirical or objective evidence. Now, if we turn to landscape, visual, and other impacts, the key issues here are described in paragraph 100. There is the Swan Lake campground. Now, Swan Lake, albeit more distant from the project, has a viewing platform on the beach side of the dune and will have quite a significant view of the project, albeit at a much more significant distance than the Lake Mombiong campground. And then, of course, there is the Great Southwest Walk itself, and both Mombiong and Swan Lake support camping, walking, day visitor experiences that rely heavily on the landscape setting and uninterrupted views across the coastal hinterland. It's worth noting that Mr. Glossop's evidence in relation to the landscape, and also that of Mr. Hark, is correct to say that it's not pristine landscape in the sense that the pine plantations are not part of a natural setting. And I think Mr. Glossop in evidence made the point that it is a environment that is ever changing because of the rotational harvesting within the pine plantation. But accepting that that is a matter of fact, it still remains the case that the setting as it presently exists is an important part of the visitor experience at these places. And so that it is modified is not a matter that removes the importance of the visual amenity of the place, just like if you had well, perhaps not just like, but it would also be the case that impacts on visual amenity would be relevant if you had a proposal that was adjacent to a more urban park. You would still be talking about the visual impact and the visitor experience in that setting. Now, the landscape and visual assessment exhibited with the EES identifies Swan Lake and Lake Monbiong as amongst the most visually sensitive, publicly accessible areas in proximity to the project. And Mr. Hark's expert evidence assesses the impact on views at these locations at being moderate to high. The submission on behalf of the proponent that nobody has taken issue with the ratings of Mr. Hark and the methodology of Mr. Hark are correct. We accept them at face value. Mr. Hark's is a very experienced and good expert, so we're not questioning the methodological way in which he's assessed the proposal. We're not questioning the images that have been assessed. We're taking that have been prepared. We're taking all of that at face value. But we do say that there is a significant potential for visual intrusion to materially diminish visitor amenity and the landscape character of the Discovery Bay Coastal Park. And that concern is amplified by the presently conceptual or high-level nature of a number of the proposed mitigation measures. And of course, it's only post Mr. Hark's evidence that we've had the high-level concepts of how mitigation might be undertaken at Lake Monbiong in terms of vegetation or potentially a jetty and so forth. They were matters that have been referenced but not fleshed out in the process to date. We accept that that's not a conversation that Parks Victoria has had a fulsome conversation with the proponent to date, and we'll address that later on. But nevertheless, the information on this issue has been thin on the ground, at least until the recent submission of Mr. Hark's supplementary material. Now, we acknowledge that he's identified potential mitigation measures, including vegetational screening and the possible construction of a new jetty at Lake Monbiong. They're conceptual. They've not been tested through detailed or preliminary site-specific assessment. There's limited information on the vegetation types, compatibility with ecological fire management regimes, or the likely effectiveness of screening. So the proposal for a new jetty is not supported by what we'd say is a detailed analysis, and it's more indicative rather than a confirmed or deliverable mitigation outcome. The implementation of mitigation measures such as vegetation screening and construction of the new jetty or the use of non-reflective bird diverters is likely to require multiple stages of design. We don't have a clear process to take us from A to B on this issue at the moment, and that's a matter that we need to do. We need to address through the drafting of the EMF. We note that there have been advances like this submission, like the other submission. There's been advances on the proponent's position through its day 2 material. So we'll be updating and providing a little bit more guidance in relation to this in respect of the day 2 material over the next few days. Likewise, will be Parks Victoria it accepts the invitation of the proponent to work with it during the course of the hearing to try and advance some of these mitigation measures, whether through the EMF or more specific matters. And Parks Victoria will be arranging, we're already in train in arranging a discussion with the proponent, which was an invitation appropriately suggested by the proponent during its submissions last week. Now, MMLV01 refers to the mitigation impacts from key public view locations and relevantly provides that consultation with Parks Victoria and the Great West South Committee to investigate and implement potential mitigation to minimise public effects on key view locations. And we just point out some matters that we will be looking to settle. Some of them perhaps have already been addressed to some extent, but some of the matters that we'll look to settle through the EMF. And then we've also addressed there the power line visibility. We think that's also been addressed now in the day 2 material, so I'm not sure that we need to trouble the committee with that at this point. We just finished by saying it's plain that the experience at Lake Mombiong, this is our paragraph 115, will be diminished by the project, and to a lesser extent, so will the experience at Swan Lake. It doesn't render the parks unusable or likely to be unused. However, in principle, Parks considers that if the project is to proceed, there should be a clear mitigation and offset priority advanced by the project. And to be completely fair, that's nothing different to what the proponent's saying. They're seeking to advance that and having good faith advance that further work from Mr. Hark. And so we'll seek to work through that with the proponent in the time remaining in the hearing to advance a position that creates a framework that will work for the proponent and Parks Victoria in its role under the National Parks Act. Now, the next issue is noise. And all we say about noise is that Mr. Dallaire accepts that the wind farm construction and operation may have an impact on visitor amenity. What we say is whether or not visitors stay for a short period compared to a dwelling. One of the problems with the application of the New Zealand standard is that treating a campground like a dwelling, correct or not under the standard, and we'll pull up the standard in a minute, is that campgrounds promote outdoor living and patrons shelter in more what I'd call acoustically vulnerable accommodation. You don't have bricks and mortar around you, and this is not a campground where you have camping accommodation. The impact needs to be assessed in the context of the Great South West Walk and its importance, noting, and we say that the IAC is in receipt of Mr. Dallaire's objective measurements and his subjective interpolation. And by that I mean that there is some work that's being done objectively in terms of the application of the standard. And then for the Great South West Walk, where the different standard applies, and in respect of the questions of the committee around visitor experience, you've got what Mr. Dallaire described subjectively. And one of the things he said, well, it'll be like a bit like the ocean, and you'll have the ocean coming in 2 directions and things like that. All of that's an impact, which goes into that broader mix of the planning scheme assessment. Now, an example of the objective measurement is the background measurements taken at a location within the project area and the modelling of projected impacts. Now, we'll come to whether the background measures are relevant under the standard in a moment, but it's just worth going to the background noise report and seeing what it says about the measurements that were taken at that location we were asking Mr. Dallaire questions about. So what it says is that in relation to receiver 673 int, the analysis for this location presented in Appendix J2 identified unique trends according to time of day and wind direction. As a result, the data for this location was separately assessed for the periods 07 to 1700 and 1700 to 07, excluding wind directions from westerlies to northwesterlies, when noise levels were found to be elevated, noting that these directions correspond to downwind conditions from the proposed wind turbines, but may relate to factors associated with the pine plantation. So these directions correspond to downwind conditions from the proposed turbines, but may relate to factors associated with a pine plantation, which suggests to us that there may be some unique characteristics of the background testing that may relate to the pine plantation. Even within these subgroups, the retained data for the night period at receiver 673 still indicates elevated noise levels at low wind speeds. Listening studies for these elevated data points indicated clearly audible coastal noise, which is likely to be a regular feature of the ambient noise environment. However, in recognition of these variations, the background noise levels for receiver 673 INT are provided for indicative purposes only. And when one goes to the table underneath that, there's actually no background data at all for the period 1700 to 0700 at low wind speeds, because the analysis is said to be in that table outside valid range of regression analysis. And I think I've got it open here, the background report. Just so this is the paragraph we've extracted, and this is the indicative background noise levels at that location. And you'd recall the evidence was that it's an evening period that can be relevant, where a receiver is said to be a high amenity receiver, and it's only at low speeds, because high speeds, the wind noise becomes a factor. And in actual fact, we just don't have background data for that period because it was outside of the regression analysis. Now, of course, the position advanced by the proponent is that that's not relevant because, and they just say so in reliance on a peer-reviewed report by Mr. Dallaire that says that these are not high amenity areas. And I just wanted to take you through pop up on screen the New Zealand standard, just to work through that process on screen, because on Parks Victoria's reading, the standard is interesting in that while it's correct to say that satisfaction of the standard ipso facto confirms satisfaction of the regulations, the Environment Protection Act regulations, it's the standard itself is not entirely objective. It requires that a party, as Mr. Dallaire used the phrase, go through what Mr. Dallaire described as the grey area to work out what the correct approach is. And I'll take you to what Parks Victoria means. So there, that come up? Yep. So this is the standard for wind farm noise that's referred to in the regulations. the wind farm, like most standards, it's got a series of definitions, and relevantly, those definitions include a definition of a noise-sensitive location. Can you see that there? A little bit bigger. And the definition of a noise-sensitive location is a location of a noise-sensitive activity associated with a habitable space or education space in a building, not on the wind farm site. And there's an inclusive definition. So it's not limited to these examples, but it's an inclusive definition. For instance, it includes land zoned predominantly for residential use in a district plan. Now, you might remember Mr. Dallaire said that these zones fall into this grey area, as he put it. And certainly the camping ground doesn't fit within that part of the definition. Then any point within a notional boundary of buildings containing the spaces in C to F. We've got various habitable spaces, teaching and sleeping rooms in educational teaching areas, temporary accommodations, and then we've got a catch-all that it includes. In some instances, holiday cabins and camping grounds might be considered noise-sensitive locations. Matters to be considered include whether it's an established activity with existing use rights. So the threshold is that Mr. Dallaire has formed the view that that the various dwellings are clearly noise-sensitive locations in respect of the wind farm, and that the camping ground is also a noise-sensitive area in respect of the wind farm. If he'd not formed that view, then the regulation of the camping ground would be left, we say, to the environmental reference standard, which is the environmental reference standard which regulates the Great South West Walk. But we don't take issue with the analysis that he's formed in that view, in forming that view. We then come to noise limits, and they're to be found at section 5 of the standard. And you'll see, to provide a satisfactory level of protection against sleep disturbance, there's a limit of the wind turbine sound levels outdoors at noise-sensitive locations of 40 dB. And it's recommended for the protection of sleep and also appropriate for the protecting the health and amenity of residents for most noise-sensitive activities. And it's recommended on the basis of background, the noise limit in 5.12 and 5.13, that's these two parts here, is recommended on the basis of background sound levels at noise-sensitive locations without significant wind. However, in order to determine the acceptability of predicted wind farm sound levels when there is wind driving the turbines, it's necessary to compare these levels with background sound levels under the same wind conditions. And we end up with the analysis that's been gone through. A relative noise limit of the background sound level plus 5 dB, as recommended in the previous version of this standard, has been retained to provide a reasonable level of protection for noise-sensitive activities while acknowledging the variable effect of winds. That's noise-sensitive locations, houses. There was then the discussion that Mr. Dallaire had about what are called high amenity areas, or HAAs. And Mr. Dallaire's been through a process and formed the view that the camping ground is not a high amenity area. Now, the high amenity area part of the standard, it says that the wind farm noise limit of 40 dBA in 5.2 is appropriate for the protection of sleep, health and amenity at most noise sensitive locations. in special circumstances, at some noise-sensitive locations, a more stringent limit may be justified to afford a greater degree of protection of amenity during evening and nighttime. It should be considered where a plan promotes a higher degree of protection of amenity related to the sound environment of a particular area. And you would recall that Mr. Dallaire went through a process of saying, well, there's nothing in the planning scheme, there's nothing specific in any policy document that says that this camping ground, and nothing in other panel reports that he'd been able to identify that says that this camping ground or a camping ground should have a higher level of acoustic amenity protection. Parks Victoria just makes the point that, and we don't contest, we can't see a panel report that goes to that point. And we agree that there isn't any particular policy that relates to this parcel of land. What we would say is that consistent with the language of the New Zealand standard, a high amenity noise limit should be considered in the circumstance specified there. But again, it's not phrased in the way that that's the only circumstance that a high amenity area might be advanced. We also get an example of a high amenity area should not be, sorry, my hand's in the way, should not be applied in any location where background sound levels assessed in accordance with Section 7 are already affected by specific sources such as road or traffic sound. All that Parks Victoria are saying is that the acoustic assessment that's been undertaken has assumed that this is not a high amenity area. We don't think it is impermissible under the standard that this is a high amenity area. It's a should, it's not a must only. And if one thinks objectively about the role of a campground in a remote area where people are exposed to conditions and sleeping, given that was the purpose of the protective mechanisms in the document in thin-walled tents and the like, we think it is open to form the view that it's a high amenity area in accordance with 5.3.1, just as, having gone through a process, Mr. Dallaire took the opposite view. Now, the last thing that we say about this is that there is an absence of background data for the site, and you'd recall the re-examination of Mr. Dallaire when Mr. Chessel put to Mr. Dallaire, well, if the background level was this, would it make any difference to the noise limit? If the background level was that, would it make any difference to the noise level, and so forth? And they were all proper questions, and they were all proper questions that the answers were consistent with Mr. Dallaire's evidence. But what we do say about those answers, they were consistent with his evidence insofar as they started from the proposition that it's not a high amenity area, right? And so that's the that's in effect the starting point. Now, 5.3.2 talks about when a high amenity noise limit should only be applied and can only be maintained under wind conditions when low background sound levels are common at a noise sensitive location while the wind farm is operating. Therefore, even when a high amenity noise limit is justified, it's appropriate to restrict the application of that limit by conditions of consent to wind conditions when the wind farm speed falls below wind speed falls below a fixed threshold. Hence, that's the important that it would be set against the low wind speeds if it were to be assessed. And they are those low wind speeds, and those low wind speeds at night are the ones that are absent from the background noise assessment. So we acknowledge that if one adopted, if this site was a high amenity area, it is possible that the limit for noise at the site would go up. For instance, if you look at the table, the noise limit summary, you might have a noise limit of 36 plus 5, for example. It's possible though that the noise limit would go down. And it's not a sufficient answer to say that the modelling that has been undertaken as part of the assessment, which is a predictive tool, that's not an actual outcome of 35 at the site. That's a predictive tool using an appropriate model, which we haven't sought to challenge, but they're always predictions. And the actual outcome as to what the noise will be when the proponent undertakes testing of compliance at the other end and works out what the actual noise levels are and where they sit relative to the requirements of the New Zealand standard. So they're the matters that Parks Victoria put in relation to the standard. It's Parks Victoria's submission that it does fit within the definition. Well, it is open to form a view that it's a high amenity area, notwithstanding it's not the explicit example that has been articulated as circumstances when a high amenity area should be acknowledged under the standard. Lastly, at 125, we say that Parks Victoria submits that the acoustic impact on the background level at Lake Monbiong and under the ERS along the Great Southwest Walk are a negative impact that contributes to the balancing impact of your assessment. It takes it no further than that. There are undoubtedly positive impacts of the proposal that you'll be weighing in the mix in the way that Mr. Glossop suggested that you might. Now, two more things to respond to in relation to material that you've got before you that affects Parks Victoria. You'd recall we asked some questions of the social impact expert about the level of consultation that was undertaken with campers and bodies like Tourism Victoria. What we understood to be the submission made on the day in response to that was that the consultation occurred during the COVID period, that people were stationed at Nelson to capture campers. So efforts were made, but that those efforts didn't bear great fruit, right? I think that was the substance of the submission. There's no criticism of that as being a process, but if it doesn't work, then you might go and do something else to try and gauge the view of the campers. Like we're now 2 years post-COVID. There is opportunity to undertake direct consultation with the people to ascertain views about the process. And that's the only point we make about that. It's not a criticism of the way it was designed at the time. It's more a criticism of, in fact, it's not a criticism at all. It's actually just a statement that you don't have the advantage of a good number of those views. We heard the submission last Thursday that there were views taken at community meetings, and they include tourist operators. They include members of the public who might be tourists. but it's not what Parks Victoria would say are targeted assessments of the views of people who use this area. The second point that we make is in relation to visitor numbers to Lake Monbiong, and we hasten to say that no expert, and we're pleased to see that no expert sought to read down impacts because of the visitor numbers or the camping numbers at Lake Monbiong. And that's important for a couple of reasons. The first reason is if you just take at one level, occupancy rates are really not relevant, because if they built a slightly smaller campground, right, then the occupancy rates might be near 100%. Right? If they built a bigger campground at Lake Monbiong, the occupancy rates would be relatively low. So it's the raw numbers of people who attend the site that are important. And what we say about people who attend these sites is they don't attend them to, it's not like going to the G on a Saturday afternoon to watch the football. You don't go to experience 100,000 other people yelling. You go there to experience usually a serene and quiet environment to enjoy nature. And so it's a factor to consider that it's a relatively small numeric proportion of the population who might use a campground like this, but it's a factor that Parks Victoria submits should be given little weight, not no weight, but little weight in the ultimate balancing exercise that you need to undertake. Because if it were something different, the experience offered by the campground would be something different as well. So you can't have volume and have the experience that the Great Southwest Walk has. So in terms of the substantive matters to be addressed in the proposal, there's some commentary on the EMF, but we'll really leave that commentary to when we submit some actual wording, and hopefully once we've done a little bit of work with the proponent about the potential for mitigation measures in the event that the project proceeds in respect of Lake Monbiong. You'll see that some of the issues are quite novel to Parks Victoria. You'll see that there's consideration of other above ground infrastructure if it's required for identiflight and things like that. That's not a commentary on whether those mechanisms should be used. That's really DECA's issue. It's really a question of if they are used, will it impact upon the Parks estate and the like. I think they're all of the matters that we need to address. We thank the committee for its time and patience with our questions over the last few weeks.
Thank you very much, Mr. Tobin. I'll just check if there are questions. Yes, Member Kirsch has a question.
Thanks. Mr. Tobin, paragraph 115.
115? Yes.
And the last sentence.
Yes.
Am I to assume that that's the work that you're doing on refinements to the EMF, or is that intended to be a separate and later process?
That is two things. One is some accepting the invitation extended by the proponent during their submissions last Thursday to do some work with them, and then to implement that through the EMF.
Okay, thank you.
Thank you. And no questions. One question from me, just in relation to the submissions you've just made on noise. I'd just like to be clear your position on the evidence before the IAC. could you just clarify for me your position on the evidence before us? Are you challenging the evidence presented to the IAC? Are you?
Well, we're in a situation where we've got Mr. Dallaire's report. Mr. Dallaire's report has been peer reviewed and endorsed, so we accept that it is one interpretation of the material. Well, let me take that back a step. We're not questioning the methodology approach or the model approach of Mr. Dallaire. We do question whether there has been an appropriate background measure taken from the Parks Victoria side. And we question that. My instructions are that we can't get record. Maybe there is record of, concerted efforts to establish something within Lake Mombiong, but I've not been provided with those in my instruction. But it may be that the proponent has more. It seemed to us that the driving factor was a concern about the security of the device itself, rather than that seemed to be the driving factor in relation to background noise. So our one criticism on methodology in terms of the objective measurements is the absence of a background noise taken at the place where the experience is, and we've got a different place. And when you go to the background noise report, and you look at the pictures of that spot, I'll just pop it up onto the screen. So this is from page 40 of 43 of the background noise report. That's the environment where the background noises were taken. Now, I'm no acoustic expert. Mr. Dallaire clearly is a very reputable acoustic expert, and he was unable to tell you what impact it would have in terms of background noises, this environment versus testing at the location. We know that it's relatively proximate to the location, but having been to Lake Mombiong, it's hard to say, but it seems to have a different sort of character in terms of its openness to the Lake Mombiong environment. It's hard to say whether it's elevated or not. I remember I asked Mr. Dallaire about what the elevations were. So we've just got a question mark on whether the background noise assessment is right. It might be that at Lake Mombiong, there's a pervasive, consistent background noise, which is very loud. That may be the case from the coast. And that I don't recall it on the day we were there, but we were talking and so forth at that point in time. So it's hard to be 100% clear on that. So that's the one technical criticism of Mr. Dallaire. We say in terms of the analysis under the New Zealand standard, we say it's a matter of judgment. We accept that Mr. Dallaire has formed a view that it's not a high amenity area. We take a different view.
Just noting your paragraph 125, so you've made a conclusion there that you're submitting that the impact under the ARS, that there will be a negative impact at Lake Mombiong and on the walk, and a balancing exercise is required for the IAC. Is there anything else that you're asking specifically of the IAC or in relation to project planning and design?
All we're really asking for you to consider whether you agree with us that there should be a background measurement taken, if possible, at Lake Mombiong. The decision tree for you would be if you accept the position advanced by Mr. Dallaire that it's not a high amenity area, then the questions you had, you've got the answers that it won't have any bearing on the project, and therefore there's little benefit in doing that. If you agree with us that it might be regarded as a high amenity area, then it seems to us preferable that a background assessment is undertaken at a location within the Parks estate close to Lake Monbion.
With any subsequent, clearly that's a investigation to determine potential requirements for further.
Yeah, but that would be an EMF related matter.
Thank you. So that's
so it's not it's certainly not a showstopper, because one way or another there will be a noise limit with which the project needs to comply, and it's just a determination of what that noise limit is.
Thank you. No,
So
that's answered.
Completely amenable to resolution in the process.
Thank you. No, that's clear. So no further questions from the IAC. Thank you for your submissions on behalf of DECA and Parks Victoria. We appreciate you coming along and presenting on behalf of them. Just a couple of things to cover before we finish. So as parties are aware, I mentioned this morning we've had a change to the timetable tomorrow. So we'll be hearing, starting at 10 a.m. here, hearing from Glenelg Shire Council, the Country Fire Authority and the Committee for Portland. So we have 3 parties presenting to us tomorrow. There are documents that have been circulated from each of those, though I understand perhaps the Committee for Portland hasn't circulated to the distribution list. So I just note that if you check, if the proponent and other parties can check the table documents, you'll see that there. And nothing else that I need to cover before we rise for the day. So I'll just ask Mr. Chessel, is there anything at your end?
No, thank you.
Thank you. And anything else from any other parties that we need to discuss before we finish today? Just quickly checking the room. No, lovely. Thank you very much, everybody. We'll see you back here at 10 a.m. tomorrow.
And from DECA's and Parks Victoria's point of view, we've got that date in a couple of weeks potentially, if required, but there'll be people observing online.
We've got more documents coming from you next week.
That's right.
Then, yes, what would be a good time to get you to confirm the closing submissions? From our perspective, to be honest, it's fine. We've got it scheduled in. If you're providing further written submissions, they'll be due the day before.
Yeah, that's correct. I suspect I'll either know when someone says something we need to respond to, which could happen on any day, in which case we'll just give you notice then. But otherwise, we'll give you notice certainly within time for you to plan your day around. I think we're the afternoon on the day.
I think it's fine. We'll assume that you will be there presenting, and let us know if that changes.
Okay, thank you. That's appreciated.
Thank you. Thank you very much. We'll see everybody tomorrow.
Thank you. Bye-bye.
Thank you.